Good morning, everyone. Welcome to IIPLA Annual Meeting 2024 USA. I welcome you all on the second day of IIPLA 2024 USA, and we shall be beginning in next 2 minutes. I appreciate your cooperation and patience. Thank you. Now, let's move to the first session of the day, Copyright in the Digital Age, Balancing Fair Use and Creative Expression. For this, I would like to invite our moderator, Yash Shailesh Bajaj, Foreign Legal Counsel, Dave Ray from US, Mark Lang, Partner O'Malley and Mayers LLP, US, Richard Gilmore, Partner Meskoff Brennan from US, Ira Sketchwords, Partner Parker and Squeshlaw from US. I welcome you all.
Welcome everyone to today's discussion on copyright in the digital age, balancing fair use and creative expression. In an era where the lines between creation, consumption, and reuse are increasingly blurred, the conversation around copyright law has never been more critical. Digital platforms have revolutionized how we create, share, and access content, pushing the boundaries of creative expressions whilst simultaneously challenging the principles of copyright protection. At the heart of this debate lies the concept of fair use, a doctrine that seeks to strike a delicate balance between fostering innovation and protecting the rights of creators. As we explore this evolving landscape, we'll dive into questions about how traditional copyright principles can adapt to an age where content is often remixed, reinterpreted, and shared across platforms in ways that were once unimaginable. As we reflect on the lessons learned from ongoing litigation and legal reforms, one thing is clear: the need for greater clarity and consistency is paramount. Countries are beginning to adapt their laws to address AI's role in creative processes, but much remains unresolved. Policymakers, courts, and creators alike must work together to ensure that copyright in the digital age continues to promote innovation while respecting the rights of individuals and businesses. In today's session, we aim to explore not only the current stage of copyright and fair use, but also the path forward. We will discuss strategies to navigate this evolving landscape, balancing the protection of creative works with the need for technological progress. So let's dive into this timely and crucial topic. I'm going to ask Richard to speak a little bit about the New York Times versus OpenAI case and throw some light on copyright infringement and such topics.
Morning. Oh, thank you. Hopefully you can see my slides okay. So I'm going to talk about the New York Times. They sued OpenAI, which is ChatGPT, and Microsoft. Microsoft is Copilot, used to be called Bing. Microsoft is also an investor, owns 49% of OpenAI. So I'm going to kind of give this overview, really kind of a quick overview of the case from kind of a 40,000-foot level. So if you have questions, feel free to ask them at any time. New York Times alleged that millions of copyrighted works were copied. And so they took approximately 16 million New York Times articles and used those articles to form the large language model that ChatGPT is based upon. They sued him in December of last year in the Southern District of New York. They alleged that millions of articles were copied during this, as part of this process, not only New York Times articles, but other articles too. From other sources, they had 7 primary counts. 4 of those were copyright infringement, 1 a DCMA claim, a common law copyright claim, and also a trademark dilution claim. So those were the 7 main claims in the case when the case was filed. As part of the complaint, the New York Times had 100 examples. And those 100 examples, when you went through and prompted ChatGPT, you entered information in, you got an exact or almost exact copy of a New York Times article that was part of the output. And so sometimes it was exact, and sometimes LLMs, they kind of memorize parts of the database, and so sometimes that would spit that out. Or alternatively, sometimes ChatGPT hallucinated. They actually made up articles and then attributed it to the New York Times. And so they had 100 examples of this as part of their complaint. So they've alleged direct infringement, as you may remember from copyright law. Direct infringement requires substantial similarity and access. And so they allege direct infringement. They also allege contributory infringement, that, hey, you knew that this was occurring and you contributed material to these infringing activities. So when someone types this in and you get an output from a New York Times article, this was common contributory infringement. And also damages. The New York Times, they rely upon revenue. They rely on revenue based upon subscriptions to the New York Times. They rely upon advertising revenue. And they also license their articles out to other people and things like that. And so they're alleging that OpenAI did this scraping and used their information without their knowledge, their consent, or any compensation. It's kind of interesting. It's very early stage of the case, and I'm not involved in the case, so these are just my opinions. OpenAI files a motion to dismiss. And they say, hey, this is not a substitute description to the New York Times. If you get the New York Times, you get it, you're reading it with your morning coffee and things like that, and they're presenting information to you. ChatGPT, you have to enter in a prompt, and then it gives information to you. So it's different thing. It's not a substitute for the New York Times. And in fact, OpenAI alleges that they hacked into OpenAI's products and took them tens and thousands of attempts to get these highly anomalous results. And so it's kind of interesting. OpenAI kind of painted the New York Times as actually, hey, you guys are the bad guys here. You hacked into our system to get these results, and these are something that you wouldn't normally get. So this is kind of a heavyweight boxing match between the two, right? And so as part of this, OpenAI says, hey, in the ordinary course, you cannot use ChatGPT to serve up a Times article at will. The New York Times responds back and says, well, wait a minute. You just type in a few words or sentences from our articles, and you get that exact article. So there's a heavyweight battle going on between right now. One of the interesting things right now is the discovery dispute going on. So as part of the discovery dispute, OpenAI says, hey, wait a minute. You only get copyright protection on things that are original and things that you own. So as part of that is showing whether or not the things are original and things you own, we get the reporter's notes. We get the reporter's memorandums. We get all your records for these millions of articles for doing this, because we get to check to see whether or not these copyrights are original and whether or not you own them. And so, that's part of what OpenAI is part of this discovery dispute, is because they have open-ended discovery questions seeking all this information. Of course, the New York Times says, wait a minute, as you know, reporters' notes and things like that, they're privileged, and there's something that's very confidential, and we don't want to do that. And so OpenAI is challenging the copyrightability of news stories, and New York Times is going, hey, the quintessential essence of copyright is news stories. I mean, those are things that are creative. People put those together, and now OpenIA is challenging the copyrightability of these things. And so this is part of a discovery dispute that's going on right now, and it's going to be fascinating to see how that kind of plays out. So let's go back to their infringement claims. The New York Times primary has 3 claims of copyright infringement against OpenIA. It says, hey, when you scrape this data from a web, it literally made copies. And so that's direct infringement because you made copies of our articles. The LLM, the large language model that was then created from that, either a copy of our New York Times articles are in there or a portion of that work is in your LLM. And so that is direct infringement also, or a derivative work from that. The interesting thing is, the large language model, to me, it was kind of interesting. The LLM, this ChatGPT is based upon, is 1.76 trillion data points. So it's an unbelievable amount of data points. I tried to figure out what it was, and it said that's approximately a Word document that's 3.7 billion pages long. And so that's the LLM that's based upon. And so the third thing that New York Times is alleging that, hey, when people say, hey, tell me about the vice presidential debate last night, from the New York, what did the New York Times say about last night's presidential debate? You type that into ChatGPT, and it will put out that article. And so they're alleging, hey, that's direct copyright infringement by the users also. So you have 3 different challenges of copyright infringement. OpenAI's defenses in this case are saying, well, the training, yeah, if we did use literal works, which if you leave they kind of seemed to admit it to me, which was kind of interesting, but it seemed to admit like, okay, we did use that, but it's for training purposes only, so it's fair use. And so that's kind of what we're going to primarily talk about is fair use. The LLM, hey, it's 1.76 trillion data points, but that's just facts. That's not copyrightable. As we all know, copyright protects expressions, not facts, and so those are just a bunch of data points. That's not copyrightable. And the third one is, hey, these individual claims when people put in an input into ChatGPT and you get this output, well, if it is, that's just fair use. If it spits out a New York Times article, that's just fair use. A couple other defenses, I'll breeze over these pretty quickly. 3-year statute of limitations. Some of these events happened more than 3 years ago. Statute of limitations applies. No contributor infringement because, well, we don't know what people are going to put into their queries to ChatGPT, so we don't have that knowledge. And, if they do, say, what did the New York Times say about last night's vice presidential debate? We say in our terms of use, don't do that. So we don't have an infringement issue there. DCMA, they took out the New York Times information on their digital copies, took out the information that the New York Times owns it. So that's part of their, it says, well, but we can do that. So that's part of their defenses. Fair use, that's one of the things. So if you have fair use, you're saying, hey, I can use someone else's copyrighted materials because it's fair. So that's primarily what we're going to talk about today is fair use. Using copyrighted works to train AI algorithms. Hey, that's the same as, hey, if you're an art student and you want to look at various people's art and then try and copy them as you're trying to become a painter, that's okay, you can do that. Or if you're a student and you go to the library and you read books in the library and you learn from these copyrighted materials in the library, that's fair use too. So that's all that we're doing. And so the primary case in this area that a lot of times that people in this industry they cite to is Authors Guild versus Google. That was the Google Books case where back in 2005 or so, Google actually went to various libraries around and said, hey, we would like to take your hard copies of your books, scan them, and make copies of those, and then we will provide the table of contents and excerpts from that book, digital copies of those. So this was back in the day when digital copies were not available. And the Second Circuit said that was fine. They said, hey, if you still wanted the whole book, you needed to go back to the library and get the physical copy. You only got an excerpt, and you only got the table of contents. And so the Second Circuit said that was fair use because it was something different from what the whole book was that you would need at the library. You could just get a little portion of that. The fair use factors here, the 4 of them: purpose and character of the use, commercial or nonprofit. In this case, ChatGPT is worth $29 billion. And so, New York Times is saying, hey, it's a commercial purpose for what they're doing. Nature of the work, in this case, there's news articles. And so those were creative works, and so those are high creative works. Amount and substantiality of the work, the third factor, hey, they copied the entire articles. And so that one doesn't seem to really be an issue. They seem to be admitted that, hey, we've copied the entire article. And the fourth one, we kind of talked about that a little bit earlier, is the market or the value of the copyrighted work. For the New York Times, you're saying, hey, people are not going to subscribe to the New York Times. People are not going to advertise in the New York Times. And people are not going to license articles from the New York Times if that information is freely available from ChatGPT. So we're kind of focusing on the first one. That's the one that's probably most interesting in this case. As I said earlier, the value of ChatGPT is $29 billion. They're substantially or the same thing as the original work. And it's for a commercial purpose. The value of ChatGPT is now commercial. So it's the value for that is a commercial purpose for doing that. OpenAI, on the other hand, says, hey, it's transformative. It's changed it into something different. And under the Andy Warhol case from the Supreme Court from last year, it's transformative. We changed it into something new. And so again, their defense is, hey, it's not a substitute for the New York Times. It's something that's different. You may remember Andy Warhol. This case was 16 photographs, one photograph that Goldsmith took back in the day in 1984. Warhol took those and made 16 prints based upon that original photograph. And so when he passed away in 2016, Condé Nast used one of those photographs, one of those, Andy Warhol, to put it on the cover of their magazine as kind of a tribute to Prince. And so the one on the right, that was the one that Andy Warhol took, but the original photograph is on the left. And so is that something that's transformative? That was the case before the Supreme Court. Was the photograph on the left then transformed into something different, or was it something basically the same? In this case, the Supreme Court said, hey, does it supersede the original work? Does it add something new? Is it a different purpose or character? Otherwise, is it transformative? And so again, this is the gray area, right? Of what's transformative or not. It says the picture on the left versus the one on the right. The one on the left, is he kind of a shy, introverted, quiet type person? And the one on the right, is he a rock star? The Supreme Court said no, said it's not transformative, said that's copyright infringement. So in this case, it's not transformative. And so, it's one of those things that's just gray area. And one of the things that will be an issue in this case is whether or not, is this something that's transformative or not? Do we make something new, or is it something just merely a substitute? Interestingly, just a couple of weeks ago, OpenAI announced a partnership with Condé Nast, of all things. And as part of this, if I'm the attorneys for OpenAI, I have indigestion right now. Because as part of this, OpenAI says, hey, we're getting this information from Condé Nast, Vogue, the New Yorker magazine, and we're doing that so we can train our AI models. And not only we're doing that, but we can provide real-time information such as quotes and contents from these articles. And Condé Nast said, hey, we're going to recover some of our revenue lost due to technology companies reducing our ability to monetize their consent. Uh-oh, if I'm on one side right now, I have indigestion in view of this. So, what's kind of at risk here? And so the amount of damages here is very interesting. So can they get an injunction? Can they stop ChatGPT? Can we say, hey, you can't use our copyrighted material? You have to stop doing that. And so either you can't have any output that has our New York Times articles in it, or do you have to create a whole new LLM and remove all of our copyrighted materials from that as part of the injunction? So very interesting. What will happen? Damages, hey, the New York Times says, hey, we generally license articles at $10 a piece. You copied 16 million articles. That's $160 million in damages right there. But plus it was willful, and plus there's also some arguments of statutory damages. And so their damages argument may be somewhere in the $2.5 to $400 billion range. And so it's very interesting what the damages may be and what the result of this case may be. So again, very early in the case, but lots of issues to kind of consider. Any questions about the case so far?
No ruling on the motion to dismiss yet?
No rulings yet. So haven't had any rulings on that. There's a New York Times wants to file an amended complaint, and that's coming up due in a week or so. Okay.
Thank you, Richard, for shedding some light on this very important case right now. What's beginning to beg inevitable questions when it comes to cases such as these are things from a cross-border dispute standpoint, right? Now, what's going to happen is that in many jurisdictions, including the United States, it requires the author of a copyrighted work to be a human. That is what the US Copyright Office has explicitly stated, that works that are created by AI without human input are not eligible for copyright protection because the law requires an author to be a natural person. So who should be credited as the author then, really? Should it be the individual or the company who has developed or trained the AI? In such a case, it would be New York Times. Should it be the person who owns the AI, so ChatGPT, OpenAI, or someone who has curated or managed the output? Also, a potential dispute that could arise from a cross-border perspective is between two companies. Say, for example, one is in a jurisdiction that allows limited copyright protection for AI-generated works, and another is in a jurisdiction that does not. For instance, a company in Singapore might claim ownership of an AI-generated work based on its copyright laws, while a company in the US might argue that the work is not eligible for copyright protection under the US. So obviously, these disputes could extend to licensing and royalty payments as we've seen. So if anybody has any questions on, kind of jurisdictional challenges, also multiplicity of proceedings, which courts are going to have and seize jurisdiction in these instant matters to rule. These are looming questions that continue to haunt us in these areas, and also in terms of harmonizing laws and also legal standards when it comes to these things. It's going to be a tough task, but I think that's where we're headed. Anything from the panel or from the audience with respect to cross-border disputes?
So one of the questions that's directly related to that is, in certain jurisdictions, Japan, for instance, and a couple others, they've already explicitly ruled that using copyrighted materials for training purposes, for training large language models or other AI, is expressly permitted. And so the question remains, if there's an issue in the US, won't these companies just decide to do all their training of their AI systems overseas, and will that potentially protect them if they bring that LLM back to the US and say, well, we trained it there, and now that it's fully trained, we can bring it back and use it here. So I think that's going to be an interesting
Absolutely. Absolutely. Thank you for that. And also in terms of, again, who's going to be the author for the output that's generated, and who can claim copyright protection? So, and which jurisdiction, would really have the authority to answer these questions? And would that create disparity? For example, if Japan, for example, a Japanese court may allow this, but a United States court may say otherwise, then can you only exert that copyright in Japan and not otherwise, right? So interesting questions in terms of choice of law, proceedings, jurisdictional challenges. We will be moving on to Ira right now. And Ira, could you please, Ira will be addressing us on some legislative aspects, whether all of these issues that have been raised right now or otherwise further issues, whether they're covered by legislation already, whether there are any pending legislations, et cetera, and also a little bit on fair use. So Ira, you have the floor.
So I've got a few slides. And they're going to bring them up in a second. So I wanted to, Rick did a wonderful job of giving you kind of the state of the law in the US of where we are with the OpenAI case. I'm trying to, I've been looking lately at the issue of deep fakes, and there's a lot of proposed legislation there, and that hopefully will give us some sense of maybe where that's going in the US and how those fair use issues there will be addressed. Okay. So these are just some images that AI is used to modify them. I think we're all familiar with what the technology can do. Everybody knows what deep fakes are. It's made news in a lot of different ways recently. One of the biggest ones was Taylor Swift. Somebody made a deep fake pornographic movie of her, and it got a lot of press, and all of a sudden Congress decided they've got to jump on this, and so that's prompted Congress to take some interest in it. They were looking at this before. Also, Drake and some other artists have had their voices cloned and used songs that have become very popular without their permission and without them being compensated. And there seem to be deep fakes have kind of got the public's attention in 3 different areas. Sex being a big one, sexual movies that have been made without the authority of the person who's depicted, music, and also election, and everybody's worried about election fraud and deep fakes. So currently, while this is being pondered at the federal level, there are some states that have taken the initiative in this. The existing state laws, for the most part, have either addressed just those topics, not deepfakes in general, but New York, California, Washington have laws regarding sexually explicit deepfakes that are made about an individual. And several additional states also have deepfakes where the images of a minor, obviously that's a criminal offense. Everybody's worried about child pornography, although there's some really interesting questions of if you create child pornography, but there's no actual child who is involved, that the image of the person is purely fictional, whether that can be a crime or should be a crime, since if no child was actually involved in the creation of it. That's a little off topic for today, but it's kind of an interesting issue. A couple other states, New Mexico, Indiana, Oregon, have specific state laws regarding deep fakes for ads involving elections. And Tennessee, which has kind of been a leader in kind of the rights of publicity. Everybody knows Tennessee has been active in this area because Elvis lived there, and the Elvis estate, I think, has done a better job of capitalizing on his image and likeness than any other celebrity. And Tennessee, for those of you who don't know, is a right of publicity law that survives death, and I believe it's for up to 100 years after death. So it goes on for quite a while. At common law, your rights of publicity, including your image and your name, image, likeness, signature, generally dies at death. A lot of states, especially those that are involved in the entertainment industry, have specific statutes where they allow that right to survive death for different time periods. Tennessee and Indiana being 2 of the longest ones. So I want to just talk about 2 pieces of legislation specifically that are proposed to deal with deepfake issues. And as you'll see as we go through them, they've got some interesting fair use concepts that arise in this, which is going to affect how we view fair use going forward. So the first one that was introduced was in January of this year. It's got a very long name, but it's, of course, like Congress likes to do, it's got initials, and so it comes out and is referred to as the AI No Fraud Act. It was submitted in January. Interestingly, both the No Fraud and the No Fakes Act, which are the 2 pieces of legislation that are pending, both only cover deep fakes involving voice or a likeness of a person. So they don't go as far as the standard right of publicity, which also covers things like names, signatures, or other identifying things. These are limited to just voice or likeness. In creating these statutes, they've come up with terminology where it's illegal to make a digital replica. That term is not very well defined. It's basically if you use digital technology to create something that includes a person's voice or likeness, that's probably a digital replica. But as we'll talk about in a second, there's some kind of complicated issues about that. I thought this was an interesting image. If anybody's a Star Trek fan, Mr. Data, who was a computer technology, if he were to sit down and take a paintbrush, I guess that would be a digital replica because it was created using digital technology. Although that's just a kind of interesting side note. So the statute establishes a very specific property right. It's referred to as an intellectual property right in voice and likeness. It applies to people while they're living and under the No Fraud Act for 10 years after their death. Although there's kind of a provision that if you stop using it for any 2-year period, it expires. Under this statute, it is transferable, so it would make it like others, which leads to some interesting things. If you transfer your right to a third party, and presumably be something in the entertainment industry, if I give somebody else to use my voice rights, what happens if I continue to speak or sing? Have I violated my own rights because I'm giving it away? That's not exactly a new issue, but it gets kind of complicated. Lots of people have given away rights to their name and image. Martha Stewart doesn't own hers. Her company actually owns her rights to her name and her likeness, but it gets complicated. We've all heard the stories of artists. The Beatles at one point weren't allowed. Paul McCartney doesn't own the rights to his songs. If he gets up and performs one of his songs, he's committing copyright infringement even though he wrote it. So these types of issues are not exactly unique, but it's kind of going to be some interesting things about if I transfer my right to my voice or my likeness and then I go out and I use my voice or my likeness, have I infringed that and what's the penalty for that? And how are you supposed, if you transfer your right to your voice and you just go around in public and talk, and somebody records it, do you have a problem? The interesting part of this, the No Frauds Act includes a type of fair use defense, and it refers to it as a fair use defense, and it basically says if there's a First Amendment defense, then that's a defense to this act. But it requires specific balancing of the public interest rights against the IP rights of the person. Both of these acts, it's kind of an important point that they define your rights and your voice and your likeness as an intellectual property right. And it's very explicit about that. And that's because of the provisions of the Communications Decency Act, which has got the notice and takedown provisions under the copyright laws. And basically, online providers are not liable for, social media providers are generally not liable under the Communications Decency Act for publishing, for placing information online. However, they can be liable if they don't follow the takedown provisions for violating intellectual property rights. So these rights to name and likeness are defined as intellectual property rights so that those online providers technically can be liable, should this act become law, for not taking down voice and likeness deepfakes. The other thing I found interesting is this is the first time I've seen an explicit reference to that your First Amendment rights have to be balanced. Generally, if you have a First Amendment right, it's absolute. The First Amendment is very clear that your right to free speech is just, Congress can't regulate your right to free speech. It doesn't talk about, the First Amendment doesn't talk about balancing that against other rights. In practice, courts do that somewhat, but there's no reference to that. Here it specifically says, well, you kind of have a First Amendment right unless you take too much money away from somebody else and their voice and likeness, and then maybe that's not okay. So that's kind of an interesting issue on kind of fair use or First Amendment rights. The No Fakes Act has some very similar provisions. This is much more recent. It was introduced in the Senate in July of this year. Again, it protects digital property rights. It's got the same explicit definition that these rights to voice and likeness are intellectual property rights under the statute. Under this particular proposal, those rights in a person's voice and likeness are not assignable during the person's lifetime. Okay, so if it's my voice or my likeness, I can do it, but I can't assign it. However, it does provide for licensing, including exclusive licensing, and I'm not so sure that there's a huge difference between an exclusive license and an outright assignment, except that under this statute, you can't license it for more than 10 years at a time, so you will get it back at 10 years, no matter what kind of license you were to give. The statute also has this interesting provision that the rights survive after death, initially for 10 years, and then after that, it can be renewed for every 5 years, and there's a registration provision that would require these rights to be registered after death in order to be valid at the Copyright Office, so the Copyright Office would have a registry of these. And the provision is it's good for 10 years after death, and then as long as during the last 2 years before it expires, it's actually somehow commercialized, then you have the right to renew it successively for 5 years at a crack, provided that you can't go more than 7 years after death. So it's encouraging, it's kind of a use it or lose it kind of provision, which is an interesting term there. Again, I'm going to come back to this one. This statute also, if it passes, has some fair like use defenses. It provides for news reporting, for things in the public interest, for bona fide commentary, criticism, satire, and parody. It also says there's a fair use exception if you use it for biographicals, films, or documentaries, including some, quote, fictionalization. I would love for somebody to tell me what that means and how much is permitted. The statute just says some fictionalization is permitted. And this is just an interesting slide where somebody starts talking about what does fictionalization mean. And it's anything from a small dramatization to a complete fabrication or a falsification. And the statute says some fictionalization. That's going to be a really interesting thing for courts to figure out. I don't know about you, but there's a kind of an interesting, there's some stupid movies out there, but they're kind of entertaining. One of them that it just came to mind when I was thinking about this is there was somebody did a film called Abe Lincoln Vampire Slayer. It's not a great movie. I'm not recommending it. But as you could expect, it's a kind of a historical fiction where Abe Lincoln is president, and at the same time, there's vampires, and he's out to save the country from the vampires. Okay? Now that obviously, if Abe Lincoln weren't quite so old, imagine that a historical figure who still has rights in this, and somebody makes a movie like that. That's obviously a great degree of fictionalization. At least I'm not aware of any actual zombies or vampires, but I don't know if that's permitted or not in the statute, and some judge is going to have to hear cases like that at some point to determine is that a fair use or not, and what could be done there. Just for some notes here, I'm not aware of what too many places are doing internationally for this. Some of our colleagues from the EU might be able to give us some more information on what's going on with the proposed AI Act in the EU. That's got a risk-based analysis, and I don't know how that's going to apply to this type of deepfakes, but it theoretically should apply in some manner to prevent those. The UK already has a proposed bill, again, which would make it a criminal offense to make sexual or intimate deepfakes. South Korea also has a statute that prevents deepfakes if it could affect the public interest. I also wanted to comment, one of the other things is, I don't know where it was. So under the fair use like defenses that are provided under the Deepfakes Act, it also says, the end of this, and this is from the statute, says it's a permitted fair use to use it with the public interest in bona fide commentary, criticism, satire, or parody. I don't know how many of you are copyright lawyers, but parody has always been a fair use, and there's been some big cases on that over the years. One of the preeminent cases on it was the Pretty Woman case, which was a song. Two Live Crew made a copy of the Roy Orbison Pretty Woman song. They did it as a parody. Roy Orbison sued, claiming it's not a parody and it's not entitled to fair use. And the Supreme Court gave us a long explanation of what qualifies as a parody and said yes in that instance, even though there was a strong commercial aspect to it, which is one of the factors you just heard about, that was a fair use and it defined parodies. However, that case says, goes on and gives some explanation, which I had to read twice, about the difference between parodies and satire. And according to the Supreme Court and just general dictionaries, parodies are making fun of an original work of art, and so you have to use the original work to comment or criticize on it, so you're allowed to use a fairly substantial part of the original work, and that's what makes it a parody. Satires use an original work of art to make a more general comment on like society in general or some aspect of society in general. That's what the Akel Froese case says. And satires are generally not fair use. So you're going to end up in this strange hypothetical if this becomes law as written, where if one work is both infringing, potentially accused of copyright infringement, and also involves a person, an image of a person, so that it involves a deep fake, and the defense is fair use, but it's a satire, you could find out that it's not, that it is not fair use for purposes of copyright infringement because it's a satire and satires aren't protected as fair use, but it is granted fair use defense for the deep fakes thing because there's this different language that's used. And under this statute, if it becomes a statute, satires might be entitled to fair use defense. So there's a lot of things to be, there's a lot of things where Congress is not evidently composed of copyright lawyers. And so I don't think they've given it that much analysis, but it's going to be, interesting for us lawyers who deal with these issues to sort some of these out. And so just wanted to leave you with a couple different kind of things here. Under this, these are all, images of people who were, were living people. Marilyn Monroe's been dead, but not yet 70 years. So the question would be, would putting these images online in some fashion constitute deep fakes under the regulations we're talking about? Probably the Saturday Night Live skit of Donald Trump, he's clearly a public figure. It's probably, making a political commentary, that probably would be, but not 100% sure. The New Yorker cover, that's Monica Lewinsky in something that resembles the Mona Lisa type image. I don't know whether you need her permission or not. It looks like it's maybe a news report, but it's the New Yorker magazine, and we don't know what the article on the inside is. And the New Yorker, if it's just if it's not political commentary, but if it's kind of more social commentary or entertainment news, I don't know. Somebody's going to have to sort that out. Now, the Marilyn Monroe painting is a Warhol painting, and that's, Warhol comes up a lot in these issues. You just heard from Brick about the other Warhol Foundation case. But if that is published online in some fashion, do you need her permission or the heir's permission? Because that was just a piece of artwork that was prepared by Andy Warhol. I'm assuming that it's used in some digital fashion. I don't know, but that doesn't seem to meet the normal fair use criteria. Somebody just used the image of somebody else for artwork. Presumably they got some kind of release, and going forward, everybody's going to get a release whenever they can. But if you do it now after they're dead, that's not a commentary. I don't know where this is going, but a lot of those things are going to have to be sorted out as to what's a permissible use for deepfakes and what is not. The other thing, the even better example, which I thought of as Rick was talking, is you have the Prince, the use of the Prince photo that was just the subject of the Andy Warhol case. If you do that, if you were to do that after these laws are implemented, is doing a tribute to somebody newsworthy and news commentary, and would that be out, or do you actually have to get permission from the heirs to run those kind of memorial pieces? Again, somebody's got to figure those out. There's going to be a lot of fair use type of issues every time somebody's image is used. The other thing is there's been a lot of commentary, I'm just going to mention this before we move on, is there's no exceptions like there are under standard copyright laws for libraries to maintain their collections, or libraries or archives, and doing maintenance or doing what they do. So if you use digital technology to maintain like an old movie that included a historical figure, but that figure hasn't been dead that long, do you need to get their permission to do that kind of maintenance? That's not what's mentioned under the fair use factors under these types of statutes. So it's going to be interesting to see where these go. All right. Now we're going to move on to Mark.
Thank you, Ira. Any questions from the audience with respect to the deepfakes and the pending bills? Sure.
Not a question. If you wonder about the AI Act, some aspects. First of all, the deepfakes are categorized by everything in the AI Act is categorized by risk. So deepfakes fall mostly to the high risk category, or when it is too risky for individual rights and the society. Let's say political manipulation falls to the prohibited category. And obligations of transparency for high-risk systems using deepfakes are that the provider must categorize and watermark the content so that it is traceable by machine, or individuals that are expertise in the subject. And the deployers also have to make sure that the consumer or end user knows that the content is created by image or sound or etc. manipulation. These are the basic aspects applicable to the AI Act, which has passed and is in effect by stage each 6 months, beginning of February.
Hi. First of all, thanks for the presentation. All very interesting and relevant to my practice. I'm outside GC to a generative AI company, or two different ones that use AI for image generation. So these issues come up, including we've talked about kind of the tension between the marketing person and and me, the attorney, when we want to sell things. And so first, just a practical example, and then second, kind of a question about where the law is going with AI, generative AI specifically. So example, on Valentine's Day, this client came to us with an image that they had generated of Elon Musk and Mark Zuckerberg making out. And they asked us, would it be okay for us to post this on Valentine's Day? And so we were able to get comfortable with that as far as right of publicity issues. One, because of we thought that parity applied to it, and two, the way that they had generated the image, it was stylized enough that we thought it was clear that the actual image of the people wasn't used. And that kind of leads to my second question. So some states like California recognize an exception where there's no actual misappropriation, so that person's actual picture isn't used. But my question is, I guess, how would that apply for states that recognize that exception when you're using generative AI? And kind of open-ended question: how do where is the line for, oh, you're not actually using the actual image? Thanks.
I'll do my best. First, I feel your pain on when the marketing department wants to do one thing and you're the lawyer who's got to say no, because we've all been there, and the marketing department always wants to sell. I don't know exactly what the answer to your question is going to be, because the technology is a little new. But one of the things I did want to mention, now that you've referred to it, is one of the general First Amendment issues is always they distinguish, at least for defamation purposes and for some other purposes, between public figures and private figures. These statutes don't make any reference to that at all, and I think that, well, if I had to predict, I think at some point judges are going to want to apply those distinctions, so that may help, and that would probably be the other thing is there was different, under these proposed statutes, some different interpretation or wording on whether or not a disclaimer will help you. One said yes and one said no, so I don't know where that's going. And I don't, in terms of the images, if you're talking about pre-existing images, you've got copyright issues. And I think that you're going to look at the state of copyright law for that. So, and as to the other aspect, it's kind of anybody's guess.
Actually, great question. Just to add to your question, I was going to ask Ira actually. Whilst these bills are pending, well, firstly, obviously, the courts are going to be the custodians for all the other rights that are prevalent, for example, defamation. And as you just mentioned about public figures and private figures, there's also a limited purpose public figure right, which happens when you're thrusting yourself in the vortex of controversy, right? So whilst these legislations are coming and you're saying that there's no mention of any of these things in these legislations, are there other recourses available to people who feel that they've been infringed upon, violated, etc.?
I'm going to give you my comments, and then Mark may want to weigh in, because I think he's going to talk about that in a moment. Well, you've got the states that have existing laws, obviously, California being a prime example. You've got to comply with their rules, and I think that's going to give us a head start. But yeah, in a lot of situations, there are some just general right of publicity that'll get you a long way. Defamation claims will get you a long way. And there's probably a lot of others we can get creative about that may or may not apply in a particular instance.
Right. We have a question as well.
So I apologize if you addressed this and I just missed it, but when I think of a deepfake, I think of an AI recreation of somebody that's indistinguishable from that person. So I think that they are doing something that they're not actually doing, or that they've never actually done. It seemed like the examples you're using there suggest that at least the No Fakes Act would cast a much broader net on the use of images that represent someone rather than actually replicating that person. Is that an accurate understanding, or have they just not really defined what is a deepfake very well?
It's, they haven't defined it very narrowly. There's some very broad language in the definition of what a digital replica is, and it's basically a depiction of a person that was created electronically. And there's a little more in the definition, but it could be interpreted very broadly. I don't know if it actually will be, because I think the problem is more specific if it's identifiable and how specifically it is. And that's obviously the genesis of the problem, but the language is pretty darn broad. And so either the courts are going to have to help determine that, or maybe before it actually gets adopted, there'll be some clarification.
Thank you. So after we've seen from Richard what kind of claims there are in such cases in the New York Times and the OpenAI matter, I'd request Mark to come out here and speak about the other kind of claims, with respect to copyright disputes.
Hi, everyone. I'm Mark Liang. Yesterday I spoke on patent issues, but which is predominantly what I've been doing for most of my career. But lately, I've been involved with more of these, all the AI litigations, investigating some of the data scraping and other types of claims that can be brought in non-patent cases. And sometimes these are in copyright cases, sometimes they're in standalone data scraping cases. When we saw this in the New York Times case, we see this in the other cases that are grabbing headlines, such as against Meta, OpenAI, Google. A lot of these cases, the plaintiffs allege not only that there's a copyright violation, but also that these companies, in allegedly violating the copyrights, are also committing other civil claims relating to the breach of security and also the scraping of data that they use to train their models. So there's a laundry list of potential claims, and I've listed the more popular ones on this slide. We see, Rick mentioned this, the DMCA, Digital Millennium Copyright Act, the Unfair Competition Law, which is specific to California law, the UCL as it's often called, unjust enrichment, negligence, breach of contract, relatedly tortious interference with contract, trespass to chattel, the Computer Fraud and Abuse Act, which is a federal law, and then the California law, California Penal Code 502. And a lot of these cases are brought up in California, or they're under California law, so a lot of the time these California statutes come up. And I guess the bottom line, just to not hide the ball right away, but for the most part, these, what I'll call ancillary claims, haven't fared very well to date. But I think a lot of it might be because of the facts of the case, or because of the counsels bringing them. In fact, in the Kadri-Silverman case versus OpenAI, or rather Meta, recently, the judge, Chabria, scolded the plaintiff's counsel as simply being unable to handle the case and asked the plaintiff to hire new counsel. So I think it might be because of that, but I think as the case law evolves, and this is new to me, but I think it's also new in terms of case law, that we might see more merit to some of these claims in certain situations, particularly with data scrapers. So I won't go over all of these. Some of them I don't think warrant that much discussion, but I'll go over some of the more commonly raised claims or claims I think have some potential merit in the future cases. The first is the DMCA type claim, which we saw in the New York Times case, but we see this in a lot of other copyright cases. And the DMCA is meant to, the copyright obviously protects the intellectual property itself. DMCA is meant to protect or provide another mechanism for copyright protection. And that in particular is to cover security or other measures to protect the copyright, technical measures. For example, under what we see in a lot of cases are two types of DMC claims. One is the 1201 section, which is to cover anti-circumvention measures and measures by and steps taken by the alleged defendant in each of these cases to circumvent those measures, technical measures. So there's two subsections here, 1201A1, which is about anti-circumvention, And the idea here is that a website like New York Times, for example, has a lot of articles and information on its website, and they might have certain measures that prevent others from obtaining certain data. That's not true in the case of New York Times. But might imagine other websites take certain measures. You have to log in. You have to have a paywall. And users, therefore, aren't allowed to simply take data or scrape it without paying or without authorization. And the idea of 1201 is to prevent people or bad actors or scrapers from taking data without authorization or circumventing technical measures. There's an ongoing appeal in the Second Circuit, Ute versus RIAA. And what Ute is doing, it's actually the plaintiff here, but the counterclaim is against Ute, is they actually run a service, a website where users can go to the YouTube website. And on YouTube, you can only stream the videos. You can't just download it locally on your computer, by default at least. But what Ute's done is you can enter in a YouTube URL, and then you can download the video locally and convert it to an MP3. So there's an argument over whether Ute was violating 1201A1 and circumventing YouTube's technical measures. Now, what's interesting about this case is that YouTube itself doesn't really have strong measures against circumvention. Anyone can go to the website. It's a public website. There's no password. There's no paywall. But there isn't necessarily a download button either. So the idea is, well, just because there isn't a download button, is that a technical measure that prevents circumvention? And the district court in Connecticut ruled that that was sufficient. The fact that you couldn't naturally just go to the website and download was sufficient to be a technical measure that prevented circumvention. And that issue is now on appeal at the Second Circuit. Oral argument's already been taken up. We'll wait for the ruling later this year, presumably, or hopefully early by next year. 1201A2, also part of 1201A, is more about trafficking or distributing tools that can be used for circumvention. So if you, for example, has distributed a program that users could use to pull website data, that would be an issue. And then 1202B has come up more often in these copyright cases. And this is the removal of what's called copyright management information. And copyright management information is actually quite broad in meaning. It covers anything that you might stamp or label onto a photo or a video or any copyrighted work to indicate authorship or source information. It could be terms of use. It could be watermarks. But removing that information or distributing works without that information when it was part of the original work is also provides a legal claim under the DMCA. The other type of legal claim that can be brought under California law, at least, and certainly in California courts, this is raised quite often, is the unfair competition or UCL provision of Section 17200 of the California Business Code. And this, while it's called the unfair competition law, it actually has three different prongs. One is that the acts taken by the defendant are unlawful. They violate some kind of state or federal law. The other is that it's unfair. Normally, this is tied to unfair competition. And then there's fraudulent behavior, which is something that's deceptive. It's actually deceiving consumers. And UCL is just, this is a law that's been used a lot in civil litigation in California. But plaintiffs are now trying to use this and tie it to data scraping or copyright infringement claims, and arguing that, in the sense that the output might be deceptive, and this is therefore fraudulent or unfair. They might also argue that it's anti-competitive. For example, they might argue that by ChatGPT doing, with the New York Times case, by taking all this data from New York Times, they're actually reducing or harming New York Times' business or discouraging publishers. So there's all sorts of, frankly, they're a bit nefarious and ambiguous claims at this point. But the law, the UCL law, is quite broad and ambiguous in its reach. And so there actually have been one or two cases where UCL claims have survived Rule 12 motions. Whether they'll go further than that remains to be seen. Another type of claim that's often raised is a breach of contract or tortious interference with contract claim. And this normally comes up in the context of data scraping. And again, the idea here is that ChatGPT, OpenAI, and all these companies, Microsoft, they have to get their data from somewhere. It's normally by scraping millions of websites, terabytes of data, and obtaining it. And that can create a legal claim in the sense that a lot of these websites, like Google, like YouTube, like Meta, like others, sorry about that, they have terms of service, oftentimes, or even contracts with certain counterparties that prevent this type of activity. So this raises claims, and the one key case recently of the Northern California X versus Bright Data, X, formerly Twitter, was the plaintiff here, argued that their terms of service are being violated by scraping data. And the contract claim actually suffers or is problematic for a lot of these plaintiffs because of among other things, the damages element. It's actually difficult to prove damages under a strict breach of contract claim. It can't be the case, when you scrape data, well, what exactly is the harm? Is there a tangible, measurable harm, monetary harm that's being suffered here? Normally, the contract itself is straightforward, it's the terms of service. The breach is straightforward, but the damage is not. It's not enough to simply say that there's a reputational harm, that people got you confused. For example, people confused your article with others. It can't be the case that there was simply speculative harm. There is a debate, frankly, among different cases of whether nominal damages is sufficient. But the element of damages has actually been a sticking point for a lot of these plaintiffs and has caused a lot of Rule 12 motions to get granted as a result. Finally, I'll turn to the the CFAA, a Computer Fraud and Abuse Act, a federal civil statute, and then the California Penal Code, which is actually a criminal statute in California, but actually provides a civil action. Both of these are attempting to get at the same issue of unauthorized or without permission access of data. But the CFAA is probably less commonly used and less promising for plaintiffs because the case law seems to have held up to this point that public websites don't qualify under the statute. So without authorization, that's the language of the statute, doesn't apply to public websites. The California Penal Code, on the other hand, there has been case law suggesting public websites are subject to the California Penal Code, and therefore obtaining data without authorization might lead to a claim under that statute. The final point I want to note here is that there have been other types of claims like unjust enrichment that I raised at the beginning, negligence, breach of contract, I talked about earlier. A lot of courts have been holding that these types of claims fail at the outset under Rule 12 because they're preempted by copyright law. And the idea of preemption, for those who don't know, is very US-specific laws. We have state laws and then we have the federal law. And if there's a conflict between the state law and the federal law, courts will hold that the federal law supersedes or has supremacy over the state law, and the state law claims then just fall away. They're dismissed. And this has come up in the copyright context. A lot of these claims like unjust enrichment, negligence, even breach of contract. The theory here is that that you breached the contract or you're negligent or unjustly enriched because you took data from me and then created something else that you want to monetize. You either passed it off or you created derivative work. And courts are holding this is really just a dressed up copyright claim. This is a copyright claim under a state law statute or a state law civil law. So courts have dismissed these saying that this is really a copyright claim and really this is, we should just evaluate this as a copyright claim. So a lot of these state law provisions have fallen away because of this. But the DMCA and copyright claims themselves can proceed under federal law. The final point, which I previewed at the beginning, is how these ancillary or additional claims have been faring. So far, again, it hasn't been very good, but I think a lot of it's bad facts or counsel issues or other problems like that. So in the, there haven't been many rulings either. This is a developing area of law. For example, New York Times, there's been some ancillary claims, but no motion to dismiss. The motion to dismiss hasn't been decided yet. The few rulings so far have been in the Caudry-Silverman cases. So these are the authors of various books, and they've sued Meta and OpenAI. on copyright, but also some of these ancillary claims. And the DMC claims, they usually raise the CMI issue I talked about earlier, stripping away copyright management information. And the claims have been dismissed so far because, well, one, they find that they aren't actually distributing the underlying copyrighted work. None of these platforms have actually been distributing the works per se, in exactly the form that they were provided. So there's a lack of distribution fundamentally. There was also, in the OpenAI matter, Sarah Silverman was the lead plaintiff there, a finding that there wasn't actually adequately pled facts that CMI was being removed. In fact, CMI, again, is very broad. It could just be the author's name or some attribution. And they found that when these works, when they're being produced as output from the training model, you could still see the author's name. You could still see information that was indicative of the source of the material. So there was no removal of CMI. In the Cadre Meta case, all the other ancillary claims were dismissed under the preemption issue that I talked about earlier. They found that all these state law claims are really just dressed up copyright claims and were superseded. In the Silverman case, the judge there, also in Northern California, but a different judge, didn't want to talk about preemption. I think perhaps a bit hesitant, reaching that novel area of law. But actually did allow the UCL claim, finding the unfair prong there was a chance it could survive or have merit if it was developed during discovery. But negligence was dismissed, finding there was no duty of responsibility from OpenAI to safeguard copyrighted works. One of the elements of negligence is that there's actually a duty of care in the first place to be responsible for and not commit the civil harm. And unjust enrichment requires a showing of fraud, mistake, or coercion. That's the cause of what's the unjust aspect of it, the enrichment, and found there was no allegation of those elements being met. So again, these claims haven't been very successful so far, but they are being brought a lot in these cases. And I think as the law develops, as perhaps the facts change, there might be more merit to some of these claims. And we might also see beyond just copyright claims that there might be just claims directed towards these other claims in data scraping cases, for example. With that, I'll conclude my remarks and open it up for questions.
Thank you, Mark. Any questions with respect to the additional claims in these kind of disputes? Right. So actually, before we conclude, I just have something to shed light on with respect to generative AI and all of these things just happening in this digital age. What's happening is it's traversing boundaries, right? AI is traversing a lot of boundaries. Now there could be potential disputes, as I said, cross-border. A lot of allegations can come cross-border as well. And again, jurisdictional issues, of course, prevail. What becomes important is the enforcement angle wherever you get a ruling. And if we're not able to enforce these, then the cross-border, then it's just going to be having no effect, right? So I want to just ask the panel and the audience as well. Are any of these disputes kind of arbitrable? For example, if we can refer these disputes to arbitration, then they come under recognition and enforcement of foreign arbitral awards and New York Convention backing. So enforcement could play a huge role then, cross-border as well, because there are so many signatories to the New York Convention and they have to abide by enforcement standards. So any thoughts on this, please?
Just an initial thought is it's going to be difficult to get there because in order to get to arbitration, either the parties have to agree to it or there's got to be some contractual relationship that requires arbitration. And a lot of what we're talking about, there is no contractual obligation except for some of the instances Mark was talking about. Certainly if there's a contract, then yes. But other than that, I think a lot of these circumstances are going to be hard to get to any kind of arbitration.
No, that's a great point. Sometimes, as I've seen in patent disputes, especially with standard effective patents, what's happening in those cases is even if a dispute does arise and there is no contract to them, there is an opportunity given by the court and between the parties to defer this to arbitration, right? And this can happen even once the dispute does arise. So in such a case, what happens is we've seen in some cases that arbitration really has been effective in some of these cases, because what it helps achieve is they can set a lot of they've set global licensing terms as well for fair, reasonable use and non-discriminatory, the FRAND guidelines, and for companies basically. Courts have gone ahead wherein they've usurped jurisdiction in the instant case, and they've also given it to the arbitrators to rule on their own jurisdiction in terms of setting these global licensing terms. So in some ways, arbitration really has helped, and it has also been enforced in several jurisdictions otherwise. So if these disputes are obviously arbitrable, and if the parties to the dispute do defer to arbitration, that makes sense. But the only problem then lies is that at the time of enforcement, there are certain defenses that can be taken up whilst enforcing the award by the award debtor, which may be that these copyright and these intellectual property disputes essentially are against public policy. And because of public policy, only local courts and national courts will be able to rule on these. So I think that's where the real concern actually lies. But moving to a more arbitration-friendly environment can, of course, help. Any other questions on this? And otherwise, we can conclude this discussion. Yeah.
So we've talked a lot about patents, of course, in the context of AI, and we talked a little bit about trademarks. Something else that I've been curious about is, when we talk about technical, the intellectual property rights to technical things, right? We often think of patents, but copyright also can apply to source code. And I'm wondering, as I have clients who are building their own AI models and they're using source code, what are your thoughts on the risk of, we talked about patent trolling, but what about attribution trolling, right, for licenses where, there are various types of licenses, but permissive licenses, you're allowed to use them as long as you credit them. Now, for commercial reasons, again, talking about that tension between commercial concerns and goals versus the legal kind of risk manager role. Sometimes clients don't want to credit open source code, and there's a risk that maybe they'll get sued because it is a violation of the license. Is anyone else seeing or worried about kind of attribution trolling for source code?
Yeah, I don't have a clear answer on that. I have seen increasingly though source code is being registered for copyrights. I've had clients do that in anticipation of, you have to register copyright to enforce it. Attribution so far has not been an issue I've run into, at least, so I can't speak to that. I think there is a risk though that with the AI models, developing software and code, that and that might be another form of IP though that plaintiffs or companies, large companies usually use to enforce their IP basically. It's another form of protection like trade secret, et cetera. So I think that might be an area that we see more litigation and development in. But I haven't seen necessarily an attribution situation. I mean, is this related to, someone will reproduce code and claim it's theirs, or what's the concern, I guess?
Yeah, I guess the concern is, in building their own code, they rely on various
Open source.
Yeah. And then, as part of those licenses, the license technically says you need to, attribute the source, but sometimes, they want their technology to look as unique as possible, and so for commercial reasons, they might not want to disclose that, and so, and advising them, it's kind of hard, to your point, to see what the risk is. It's just something that I've been thinking about because, as everyone's attention is on AI, both to regulate and also to make money off of AI. It's kind of just wondering what, I guess we don't know, but what is the risk of people, just like people patent troll, maybe they attribution troll?
So wouldn't that essentially be a breach of a copyleft license? And that could then just become a contractual dispute as well if somebody's not crediting their code to the open source, and then they're also monetizing after using the open source code in their own code. So I think that would become more of a contractual dispute, and to what degree has that open source been violated and it's been used? in your own code, and how much of, I think Mark shed some light on unjust enrichment, and also whether such a claim could be quantifiable in terms of then restitutionary damages and also disgorgement and those things. But yeah.
Yeah, I mean, if someone's just passing off code as theirs when it's not, I guess that would raise some of the claims I talked about, the ancillary, the additional claims. So CMI would be an issue, because CMI, again, is pretty broad. It's just it's basically attribution information. If you remove that or try to pass it off, it could be an unfair competition. You're deceiving users. There's a fraud aspect to it. So I think there's a lot of measures in place, or legal claims that could be, that I talked about, that could be brought in that situation, if that's a significant risk. So
I haven't seen too much of it because open source usually comes with other requirements in addition to the attribution, and so a lot of the people who are developing this want to make sure it's completely proprietary to them, and so they usually try to exclude open source if they can, because I think, well, attribution could be one. They may have other problems too, depending on the open source license.
Any other questions? Yeah.
I just want to add comments on, you just mentioned about arbitration and litigation or
Yes.
judgment. For example, because China and US both are the members, contractual members to New York Convention. So if you get a winning arbitration award, that would be relatively easier to be recognized and enforced in China. But if you get a winning judgment issued by US courts, that's almost impossible to be recognized and enforced in China. So you may have, if you say you get a winning judgment here, but you have to come to China to do it over again, to litigate again and get a Chinese court judgment in order to have it being recognized and enforced in China. Okay.
No, absolutely, that's a great point, and that's what I was getting at. Arbitration would be the best mechanism in terms of enforcement. But then again, the problem would be if the award data goes to a Chinese court, when the award is trying to be enforced in China and raises a ground of, or a defense to avoid enforcement on public policy grounds. And they say that only national courts could actually be custodians of these intellectual property matters. So that would be a potential area of concern, according to me, when it comes to international arbitration per se. What would help in recognizing and a US national court decision in a Chinese court would be the principle of comity. But then again, because of the varying IP standards and legal standards of intellectual property in terms of what would actually constitute fair use in the United States and in China, what would actually constitute infringement in the United States and China, there are these concerns would actually be an issue, and therefore giving comity to an international decision would become problematic. But thank you for your point. Any other questions?
Can I just follow up on that? I think it's
Please.
a bigger risk the other way around. If there's an arbitration award issued in a foreign judgment and you bring it to the United States, you've got the same public policies, but the United States is the only country that has a First Amendment in the nature of ours. And that's, I think if you had a judgment and somebody could say it violates our interpretation of First Amendment rights, you'd have a hard time
Enforcing.
on passing grounds enforcing it in the U.S.
Absolutely, which is the only, which is a massive hurdle in actually the New York Convention, and the New York Convention does provide this as a defense as well under Article 5. Comity could probably help better, but again, there's a varying legal standard problem. Any further questions? Seeing none, thank you so much, and.
Thank you so much for the wonderful opening. I request all the panelists for this session to be on the stage so that we can honor them with our token of gratitude. Thank you so much. Let's move to a short networking break for 5 minutes, and we'll resume the session at 10:45. Thank you. Let me click a photo for you. Let me click a photo. Welcome back, everyone. So let's start with the next session of the day. All right, now let's move to the next session for the day. It's crafting a winning IP strategy from patent application to trademark registration. For this, I would like to invite our moderator, Calvin Wong, Vice President, Jamster Capital from US. And the panelists are Matthew Holhan, partner, Quarles and Brady, LLP from US. Surbroto Bose, Head of IP, Astra Labs from US. Madhumita Datta, Consul, Lonstin Sandler, LLP from US. Kumsi Khanna, Director, Khanna and Kumlo, Incorporated, South Africa. David Callis, Founder, Callis IP from US. And Yogesh Bharadwaj, Managing Partner, Logis IP LLP from India. I welcome all the panelists on this stage.
We're missing a panelist.
We just have to cover the rest of the 30 minutes.
Okay, I mean, nobody's back anyway, so I think we just.
Half of the room is on the stage, right?
We've got a 2-hour marathon.
3-hour, 1 hour.
So hope we're all ready for that.
So who's left?
Okay, let me
Someone said they saw him, so he's probably floating around. We can start? Thanks. Good morning, everyone. Hello? Hello, hello?
we can start with the session.
Ready? Well, everyone, welcome to this session about crafting winning IP strategies from patent applications to trademark registrations. This is a very, very big topic, and we have a very large panel here to talk about the various aspects of IP strategy. I'd like to start maybe just having the panelists introduce themselves quickly, and then I'd like to jump to my first question, which is really around the definition of IP strategy. I think we hear that term tossed around a lot in our industry, and different people have a different definition of what that means. So I'd like to ask each of you to sort of define what IP strategy means to you, what you do at your firm to help enhance that for your clients. And then we'll start there.
Hello everyone. My name is Yogesh Bhardwaj. I'm the managing partner at Loisi's IIPLA. It's a IP service boutique firm, and yeah, I do work as a IP strategist and help our clients to strategize all their IP. IP is not only patents, trademark, but there is other aspects as well. So we need to secure a bit in a technical approach. Yeah. Thank you.
Hello, my name is Subroto Bose. I'm head of IP at Astera Labs. So Astera Labs, it's a chip semiconductor company. We make data communication chips for cloud data centers. It's a young company. So our portfolio is growing, our product line is growing. Before Astera, I was at Marvell Semiconductor, and before that, I was at Dolby. And in my past law firm career, I've worked on both patent litigation, patent prosecution. But I view IP strategy as literally looking at what the company is trying to do and using all the tools you have at your disposal to make the right decisions, which includes, of course, patents, trademarks, design patents, if there's need for that, open source. That's a big issue. What is being open source, what we should not open source, and trade secrets as well. So and you really have to you have to look at what the objective is and decide what should be done. And fortunately, because Esther is a really young company, I had the opportunity to actually do all this from scratch when I started. So.
Hi, my name is Madhumita Datta. I'm a IP counsel at Lowenstein Sandler. I might have the record of having the closest office from this venue. I literally have to walk like 0.2 miles to come here. So we are a national firm with offices in New Jersey, New York, Washington, D.C., Utah, and here in Palo Alto. I am mostly, my expertise has been for the last 18 years has been in patents because of my background. I have a PhD in electrical engineering. But I do advise clients on overall IP strategy, kind of like what Subroto and Yogesh were saying, that IP is not only patents, it's trademark, sometimes trade secret, design patents. So, but my personal experience is in patents, and I guess a lot of the times my IP strategy centers around not losing the opportunity to get a competitive advantage over your, basically the same players in the field. So we will talk more about that, but wanted to pass it on.
Hello, my name is Matt Hollahan. I'm a partner at Quarles and Brady. I had my 1-year anniversary with the firm yesterday, so it's still kind of new for me. My focus for most of my career has been in IP litigation, mostly patents. More recently, I've been doing some TTAB appeals and doing some more trademark work. I have developed various IP strategy protocols for various clients of different sizes. I don't really have a unitary view of what an IP strategy should be. The first step in my work is always, how does IP fit into your business objectives? Are you an IP-driven business? Are you a tech-driven business that happens to develop patents sometimes? Is IP a problem for you because you're always getting sued for patent infringement? And there are different ways to, meld IP into the business objectives depending on the type and stage of the company.
Good morning, everyone. My name is David Kellis. I am the founder and a patent attorney at Kellis IP, which is in Salt Lake City, Utah. And previously, I was a shareholder at an IP boutique in the Denver, Colorado area, where I worked for a time with Matt. And then also, I just got back 3 months ago from living in Brazil for 3 years, where I was the USPTO's intellectual property attaché in Brazil. As far as the question of what is IP strategy, I think IP strategy is a subset of business strategy and needs to be completely aligned with business strategy. And also think that IP strategy needs to encompass IP policy as much, as an important component in addition to all of the other aspects of IP protections. And I say that because, in a place like the US, maybe any one company, particularly a small company, won't have an opportunity to influence IP policy that much, but in other countries, IP policy is not necessarily as rigid and could be influenced in ways that could be very beneficial for a company just as much as getting IP protection in that country might be.
Thank you. Good morning, everyone. My name is Kumisi Khanare. I am a co-founder of a law firm based in Johannesburg under the name and style Khanare and Kumalo Attorneys. We have been running for just above 10 years now, and I do mostly trademark law stuff, so I'm a trademark law practitioner. And for me, IP strategy really, can never be complete if, all elements are not covered. And I'm talking, patents, trademarks, trade secrets, designs, and copyright. So whenever that has to be dealt with, for instance, I would have to invite other colleagues that are not part of the firm, but just to make sure that we tick all the boxes that need to be ticked insofar as that strategy is concerned. Thank you.
Well, thank you everyone for answering the very first question. It sounds like there's just a lot of diversity in terms of how each of you define IP strategy. And even within that definition, there's different instances where certain strategies or certain tactics may apply. Let me try to narrow down the question a little bit. Yogesh, when you and I were talking over email, you mentioned that IP strategy for startups was an area that you wanted to particularly focus on. I know that was a topic we covered yesterday, but I'd like to hear your thoughts more specifically about IP strategy for startups, maybe how that differs from larger companies, as well as some of the challenges that you see startups run into.
Yeah, absolutely, because startups are budget constrained, so they don't have much budget, and so they need to see like if they are starting with one product or with one services, and what they can secure in terms of IP. If they are launching only one product, because startup usually launch one product or a one service or a one digital product. So I think the right consultancy and the discussion should be there, because they need to be advised like whether they can file a design patent or a provisional right now, or they can secure artwork or the copyright there, because these little subsets go align with the business strategy as well, because later on when you grow, then you understand the value of these IP. But initially, a lot of startup founders and co-founders don't understand the value initially. So I always say them like, you need to see that you are securing your future now and leveraging it, creating an asset along with your product. Yeah.
One follow-up question to that. I think one challenge that I see with a lot of startups that I work with is that they're innovating so quickly, but they don't really know what's going to work and what's going to stick. So how do you advise them when it comes to patenting, when it comes to trade secrets? When do you lock in your invention versus when do you give them more time to decide what's the right path?
So whenever any clients come to me with an idea, so usually they don't know what is the novelty is there in their product or in their invention. So the best point is, first they need to identify what's the problem they are solving. Because identifying a problem and providing a solution, and your solution should be unique. So that aspect initially give you an head-on so that you will be unique when we do a patentability search. So if you are solving a problem and your solution is also unique, so there are more chances in patentability, the search outcome will come in your favor. Right, and when it's come, then they need to discuss again. Okay, what are the point? What are the feature? Then you can secure. You cannot secure everything, but usually startup founders say, "I need to secure everything." You cannot. You need to just focus on your product, or in your technology, or your core aspects. And apart from that, I always advise them to secure their design patent if there is a product, or if they have a digital product. So I always advise them, if you're creating your graphics uniquely and you have your icons and everything, then you should go for copyright as well, because you have something. Like if you have, something is better than nothing, like to stop anyone. Right? So that's it.
Yep. Just add on to that first.
Please.
So one thing is, I think if you're a law firm trying to advise a startup on IP strategy, I think it's very difficult. Part of the problem is, you just don't know enough. The startup founders may not necessarily be the most receptive to spending money on IP rights. But I've been on the other side. I've been now at startups, trying to do develop IP portfolio for startups, and then focus mostly on patents for this discussion. The usual challenge is, of course, there's a budget constraint, right? But also, you're designing your strategy with the standpoint of you might not have money now, but you need the patents, but you expect to have more money in the future. The next year is going to a higher budget and so on. So filing strategies matter, and what you file also matters in some sense. So it's some of the things that are worth looking at is filing very substantive applications that essentially planning for continuation practice. So because essentially you file only one application now, and knowing that you're including multiple inventions in it, and you'll actually file continuations later on, at least in the US, that works well. And that also helps because you delay prosecution costs. It's not just the drafting. Sometimes you may have to pay more drafting fees up front because you're actually putting in more than you should be putting into one application, but it helps in terms of delaying prosecution costs, and that's worthwhile. The second thing is the filing strategies matter. So if you have a limited budget, one thing that you optimize for is, I'm assuming you're going to file multiple applications. So now you have to decide, where should I spend my money actually? So because let's say you can file just 10 applications. The challenge with being sort of develop a portfolio for startup is, I want to be right every time. So essentially, every application I file should issue with the right claims, which is not. Big companies also have budget issues. So the budget, they're just solving for a higher budget, but they can sort of, if some of the applications don't work out, it's not a huge problem. But if you're looking at a universe of 5 or 10 applications, you're trying to be right every time. Prior art search, doing a prior art search matters, but also I think a great strategy is to actually start with the PCT application, not even bother with the national application. Start with the PCT application, designate EPU as the search authority, and look at the search report. See if if the invention you think is worth patenting is really going to pan out. And if you're exploring the space, and the other issue startups quite often have is they have several ideas. They don't know, if you're at an early stage startup, you don't know what's going to pan out in the market, and you also don't know what's going to be patentable when you try to get a patent. But early search, so you could file multiple PCT applications directed at some of the areas that are of strong interest. I mean, PCTs also get expensive, so you can't do this every time. But that search report could guide you in terms of where there is art. Maybe you should not actually develop. You shouldn't put that much effort in that area because you can't protect yourself with patents in that area. So innovative filing strategies make a lot of difference. And PCT, of course, the good thing is it delays the prosecution costs for a long time if you choose to use it that way.
I think another option for startups that are budget constrained is to take advantage of some of the leniencies in the U.S. patent system. So you have your 1-year grace period after your first public use or disclosure. You have the complete, the effective lack of formalities for a provisional application. You can file whatever you want as your provisional application. You can file a napkin with your ID on it, right? So I've had clients file their investor deck as their provisional, and you save money on legal fees. And that provisional, it does get the clock ticking, and I feel like that can motivate the company and the client and the lawyers to really focus on their IP strategy and make sure that when the conversion deadline hits, they're ready to, pick a path. So that's and I know that lawyers may not like not being able to write provisional applications, but it's very helpful for startups to be able to do that.
Has that ever backfired where somebody files a sort of weak investor deck without the right spec support?
Oh, sure. I mean, well, yes. The patent office will accept your priority claim, and then on the off chance that the patent gets litigated someday, I mean, the patents I work on, I always assume they're going to get litigated, even though very few do. That's a whole big fight about the priority date. Does the provisional support it? The nice thing from the IP rights standpoint is that at least my understanding of the case law is that the question of whether the provisional application supports the later claims isn't as demanding as like the enablement best mode. Like it's not a full 112. It's really the written description possession test. Like, did you actually have these ideas? Yeah. So, you know, I've seen a one-page invention disclosure statement that just in 2 paragraphs describes the problem and the solution, and the specification is, you know, 20 pages long. And it worked because the basic bones of the claims were there in that invention disclosure.
Just adding on to that, it's important, I think, for startups especially to realize that you're not limited to one provisional application. So you can file your investor deck. And let's say, to get back to your original question, Calvin, you know, the lean startup model is that a startup is trying to figure out what do consumers actually want. So they might come up with one thing, but then file a provisional application on that, and then find out that they actually need to go in a completely different direction, right? So then maybe they need to file a different provisional application. But if they do what Matt's suggesting and just file something simple right away, as they develop that, they can keep filing new documents as provisionals, right? Maybe you write a white paper, maybe you write a scientific article. All of that can also be filed as a provisional. And as long as, well, when you do finally file your non-provisional patent application, you can claim priority to multiple provisional applications. So that gives you more leeway than you would otherwise have in terms of you know, making sure your bases are protected without having to spend a whole lot of money up front.
Just to add on to what you said, you know, ordinarily with you know, trademark applications, you will be informed by the business case, you know, as you start, and you know, it's most of the time a living, you know, idea, if you may, especially for startups. And as they, you know, get the project off the ground, you know, you always have to be mindful that there will be, you know, spin-offs that you know, come with implementation of the business case, and also growth into other, you know, areas and jurisdictions. And as that happens, you always have to, you know, like you said, you have to file additional applications for trademark protection and prosecution. So you always have to have that in mind to say, as the business gets off the ground, as you know, the first pilot, because sometimes it's just a pilot phase, focusing on a particular area and a particular market. And as it gets implemented, then there are spin-offs and there's growth, and you need also to cater for that.
Just wanted to add a particular case for a big company's patent filing, because we have been talking a lot about startups. So I have a semiconductor client, you know, who for one group for that client developed a technology, kind of the rudimentary concept of the technology, and then a patent attorney wrote a patent application where they put a lot of ideas into the patents. But later, another group, a completely different group, so no like overlapping inventors or anything, they developed a much better solution, which was actually commercially useful for the company. But then, and you know, they filed another application with this later solution. But in the patent examiner's eye, all the conceptual ideas were already covered by the previous patent, which is, you know, it was filed like 5 years back when people have just the rudimentary ideas. So I can see for a startup, you know, where you're budget constrained and you're trying to kind of exclude competitors, throw in a lot of half-baked ideas in a big omnibus patent, that can work. But I usually tell my bigger clients that thinly slice your patent applications, because you never know how you're going to sabotage your own future better solution by creating prior art against your own future application.
Yeah, I think that's an interesting, you know, different schools of thoughts about how to file applications, right? I think there are certain attorneys that would advocate filing an omnibus application and just pulling from it whenever you feel like you need to have a new set of claims, and the danger of that is you might end up tripping over yourself because you've got prior art, and maybe you end up with a very, very messy continuation in part or something like that. So anybody in the panel want to speak to?
This is kind of where strategy comes in, basically. There's a balance between how much you put in a patent application and what you keep out. I think in some sense, having a patent application directed at just one idea itself is, I don't think, it could work in certain situations. It's not the best idea, especially if this is sort of, if it's part of a system, there are multiple inventions in the system. It is always more interesting to actually combine related inventions into the same patent application. Because what it lets you do is down the road, I mean, you may not have thought of all the possible ways people are going to use these concepts, but if you have everything in one application, down the road you can do continuations that combine ideas in that original patent that didn't look interesting when you first filed it. So you have to broaden it a little bit more behind. Generally I don't, for a startup, I don't file that applications on just one idea, partly because it's too risky. If that gets rejected, I don't have a patent at all, but also I don't know all the use cases. But also this, what I think what Madhumita is referring to is, the gratuitous, sometimes some inventors and even some patent attorneys just throw in like a few sentences. Yeah. That's always a bad idea, but that always comes back to you. If you don't know enough about the invention to have a figure and have at least a couple of paragraphs, keep it out. And I see that all the time, and I keep that kind of stuff out.
100% agreed. Like, if you cannot even write like 2-3 paragraphs describing a figure.
And at least one figure, yeah. If you don't own the invention to that extent, you shouldn't put it in. It doesn't help you in the long run.
I would like to add one point in this. So startup founder never see an infringement risk when they start doing a product. So sometimes they see, okay, I file a provisional and then I'm secured, right? But when they are developing a product or a service, there might be some more patents that you are already infringing, right? So sometimes it's good to have the infringement check also with the product and the services. Yeah, patentability is about patents, right? So whether your invention is novel or not, but suppose it's not novel, but you are infringing, then you should also know that. But that's area is never more discussed in the starting. I think that should also be a point of discussion.
Do you think that's best handled by like a freedom to operate study? How do you?
Yes, freedom to operate study. Yes, yes. So suppose if your idea is not novel, then you should do the freedom of operate, absolutely. If you are have the strong intuition that I should go, because guts are like the favorite thing for the startup owners, like they will go always with the guts, right? But they should be clever, yeah.
I think one question that I get asked by startup founders when we talk about freedom to operate is, like willful infringement, right? You're starting into a space that a lot of people are investing in. You're likely to find something out there. How do you think about the scope of the freedom to operate study? Are you focused on specific known risk? Is it really a boil the ocean exercise? How should a startup founder think about to what extent they should want to understand the risk that's out there?
Okay. The one point is the jurisdiction where they want to do the business. Then it's jurisdiction specific. FTO is jurisdiction specific from where you are making or where you are selling it. So that's one point need to be considered. And other is like if it's not that you didn't get the clear aspect or approval in the FTO as well. So if you made, you will infringe. If you don't, then what will you do? So the right strategy is to see the patents and innovate. Yes, right. Design around.
All I would say is I think freedom to operate studies can be expensive. It's much cheaper and probably more. But the way I look at it is, well, from a business standpoint, I'm not a business guy, I'm a patent person. So if I'm worried about prior art, the prior art I'm worried about is prior art from the patent office. And the best way to utilize that is to get an EPO search done. So that's the reason I keep saying either file an EP application or PCT application if you're not sure. Get the EP search report, look at it carefully. That's in the long run, that is actually, I think, more comprehensive and cheaper and probably more thorough than the freedom to operate, because I have unlimited faith in the European Patent Office.
When it comes to willfulness, I think your freedom to operate strategy depends entirely on where you are in the process of product development, and hopefully you're at the beginning of the process so that you can change easily your course if you come across blocking prior art. Excuse me. If you're in the unfortunate position of, your client has a product all ready to go It's gone through all of the, the entire design process. They've got all the marketing ready to go. Now your freedom to operate search may look a little bit different because maybe now you're just trying to avoid a willfulness finding instead of actually trying to guide where are we going to innovate. And in that case, maybe you don't want to find as much.
And I think there are options on that as well. I mean, one nice thing about Google Patents, for example, is that you can do kind of spot check prior art searches pretty easily. At the firm where David and I used to work, Sheridan Ross, we had an associate who could just do a prior art search for you for like $3,000, and it was very thorough. If there was prior art out there, he could find it for you. So you don't necessarily have to do, I mean, if you want to be as thorough as possible, yes, the European search is going to cover everything, but you don't have to go and do, a $12,000 prior art search from a vendor anymore. And I think it really depends on how discrete your idea is, right? And if there's room to maneuver in your design process to get around prior art, then that's an advantage as well.
Again, just will add something that the freedom to operate or even patentability searches, I was talking about this in another session about focused on startups. Most of the times I do those searches for my smaller clients who are at a greater risk if at a later time they discover that they have already designed the product and now they're infringing somebody, they don't have the manpower or the resources to now fight that bigger patent litigation. So just risk management for startups and smaller companies. But for bigger companies, I mentioned that yesterday's panel also, nobody is doing any search before filing the patent. They are actually telling their inventors, don't even look for it. Assume you are inventing the greatest thing, in the world. Let the patent attorney write it like that, then the burden is on the USPTO to find out the, the relevant prior art. And during the prosecution, if they realize that, some really good prior art has been unearthed, then they will just drop the patent. That's their strategy.
Yeah.
This is mostly for the bigger companies.
That is absolutely what your big company should do. You should definitely tell engineers never to read patents ever, which is tragic because the entire point of the patent system is that there's all this wonderful art and technology out there for engineers to look at and review and improve upon and draw from. But we've now incentivized innovators to do the exact opposite and pretend patents don't exist. But that's a political issue.
Yeah, I think practically speaking, they do read it. They just read it on their personal laptops and not on their company laptops.
Actually, not quite. But you're also assuming that engineers can actually read a patent and they'll find it interesting reading. Most engineers, they might read their own patent applications. They just don't want to read other people's patent applications, except for a few. One thing I do is, we do the same thing. We don't tell people not to read patent applications. If they need some clarity, I'll get a prior art search done and to give them the feedback. One thing I always do is ask people, how did you think of this invention? And sometimes that leads to surprising answers. If they derive the idea from somewhere else, I know that up front. It just happens rarely. Most startups, they're really inventing something and it's a new idea. But sometimes they'll say, I looked at this paper and saw this and this kind of, just using the same idea somewhere else. And at least you know that up front and you can draft the application around it if you ask that. But it's a compulsory question in general.
Yeah. So I would like add one point. Like in startup, I think it's recommended to search and do prior art search before starting. But for the big companies, I think the best strategy is for them is to educate their R&D team well, so they know a little bit doing basic search first before sending an idea. So once if they do a basic search, they get to know what is in the past, what is in the market, and whether it's same or not, and how more they need to drill down. Right, then they understand it. So educating the R&D team along with the patent practice is a very good strategy for big manufacturers, and most of big manufacturers also do that. So
there is a jurisdictional difference, right? Unfortunately, in the US, you have willfulness. So if you somehow, the company had knowledge of the patent or the engineer had knowledge of the patent, then you're liable for willful infringement and the damage is triple. That's kind of the reason why we don't do it in the US. And I've been a litigator, right? Essentially, if a patent gets asserted against you, one of the search terms that you have to search for documents is going to be the patent number. And if you even touch the patent, it's going to be in your hard email somewhere, but you can't hide the fact that you looked at a patent. So it's just to the extent that if you absolutely don't need to show them the patent, don't show them the claims. So at least they don't know what the claims are, and that gives you some level of protection.
Yeah, that makes sense. And I'm sure each of us has seen some horror story about, an engineer emailing another engineer and saying, hey, I think we infringe on this technology.
Oh, it's even worse.
I'm pretty sure we do, in fact.
Just patents should not be subject to conversation, because other stuff that happens is you get a patent allowed, and someone says, I can't believe that got granted.
That is also one. I want to come back to the topic of, I guess, strategy implementation and client management. But before that, maybe just shift gears a little bit and talk about, a global IP strategy. We've talked a bit about IP for startups. We talked a bit about risk mitigation. But a big part of IP strategy is just thinking about where to file and I guess what to file where. And maybe, Dave, I'll start with you. I know you've got quite a bit of experience working in Brazil, and I'd like to hear your perspectives on that.
Sure, thanks. So actually, I put together a brief presentation that I'll share about IP in Brazil. And we can kind of treat this as an intermission because I'm the only one who put together a presentation on the panel, so hopefully I won't take too much time here or distract from the other things on the panel. But while I was in Brazil, I talked to U.S. companies that would call us, and they would want to know, what they could, they were interested in the market. They'd realized that Brazil is an interesting market, and they wanted to, come down there, and they wanted to know what the IP landscape was. And it was unfortunate that many times we had to tell them, we'd ask them questions, and they'd have been in business for several years, and they had several patents issued and all this stuff. But oftentimes it was the case that they had missed the opportunity to protect their IP in Brazil, and that's an unfortunate message to have to deliver to people, right? And so I wanted to put this together, not to tell you that you and/or your clients should include Brazil in your IP strategy, but to raise Brazil as a potential place to consider. And make sure that if that is of interest to you or your clients, that you don't lose out on the opportunity to do so. So Brazil is not a country that's super well known here in the US for whatever reason. It's not a very highly visited country by US citizens. It's a country that many people associate with the Amazon and not much else. But actually Brazil is the largest country in Latin America. It's one of the top 10 largest countries in the world, with one of the top 10 largest GDPs in the world. It's the 4th largest democracy in the world. And they have lots of industry that's interesting: civil aviation, agriculture, information technology, oil and gas. These are industries that are responsible for huge amounts of money, and industries that are relevant to a lot of the industries that we have here in the US as well. And then also, it's relevant that Brazilians hold a favorable view of US products. And so, Disney, for example, is wildly popular in Brazil, and Apple products are very popular, right? It's just a country that enjoys US products and US culture, and therefore it's a market that can be very interesting to US companies. And then one last point is that the government of Brazil is, like many governments around the world, investing tons of money in reindustrialization of the country. And that, I think, is relevant for two reasons. One is because there's money potentially to be had by investing in Brazil. And then also because with all of these incentives to innovate in Brazil, it might be more relevant to protect your IP in Brazil to ensure that it's not encroached upon by someone else. So let me start where the rubber hits the road, which of course is with IP litigation. Because if you can't enforce your IP in a country, then it may not be worth protecting it there. But in Brazil, I'm happy to report IP is enforceable. And the courts of São Paulo and Rio de Janeiro, which are the two largest cities in Brazil, have specialized IP panels, both at the first instance level, the trial court level, and also at the appellate level. And then the Superior Federal Tribunal, which is the highest non-constitutional court, also has two panels that specialize in IP. Now, the São Paulo courts are technically the very best. The Rio courts are technically very good as well, but arguably more influenced by political issues. Some things to know about litigation in Brazil include that it's a bifurcated system, so you'll file your infringement case in state court. The invalidity case will be filed in federal court, and that case will name both you as the rights holder, or your client, right, but also the Brazilian Patent and Trademark Office as a defendant. And so if you have been upfront and forthcoming with the Patent and Trademark Office, then, and they've granted you a right, then they will defend that right in court next to you. But if you have been deceptive towards them, then they will totally stab you in the back when it comes to the litigation, right? They'll say, well, yeah, we granted this right, but the applicant wasn't forthcoming with us, and so we don't think the right is valid, and of course that would hurt your case. There's no traditional discovery in Brazil as we understand it, which is good and bad for plaintiffs, right? That means that the time is on your side. You can have all the time in the world to gather your evidence and put it in the complaint. Once you file the complaint, the defendant only has about 60 days to come up with a response. And also, if you're alleging infringement of a process patent, you just have to show probable cause that there's infringement, and then the burden will shift to the defendant to prove that there is no infringement of your process patent. With experts in Brazil, the court will appoint its own expert if a party asks for an expert by motion. And so parties typically do retain their own experts, but those experts just advise the party with respect to the opinion that the court's expert comes up with, and providing any commentary to the court regarding that opinion. And finally, the all-important question of remedies. So the big key thing about patent litigation in Brazil is that injunctions are available, right? So that's preliminary injunctions, permanent injunctions. In Rio, if you're very likely to get a preliminary injunction granted, maybe even ex parte very quickly. And if it is ex parte, then a few months later there will be a fight about whether or not the preliminary injunction should stand. The São Paulo courts will look at it more closely, but they also are willing to grant preliminary injunctions in most cases. As long as similar standards to the U.S., right? You have to show that there's, that you're likely to win, that there's harm being caused. But in Brazil, they generally understand the infringement of IP rights to satisfy the harm question, right? And so that's an easier process. And then also there's monetary damages. The winner gets attorney's fees and 20%, costs and 20% of the stated value of the case as attorney's fees. That rarely comes close to what the actual attorney's fees were, but then you can also get lost profits, damages, whatever unjust enrichment the defendant enjoyed. As far as timing, cases lasts a couple to a few years, maybe a little bit faster than in the U.S., but there is some slowness in the process. And then in terms of cost, it's definitely cheaper than here, but it's not as cheap as some other places that you might be familiar with doing litigation. So if you go with the big law route, the big law of Brazil route, then you're probably looking at $750,000 to $1 million to go through appeal on a patent infringement case. If you go the non-big law route, and of course, as we all know, there are plenty of very experienced attorneys who don't work in big law, then that can be half or even less than half of that big law cost. And then trademark infringement litigation is generally much cheaper. And then finally, you don't have to worry about being from out of the country. Brazilian courts will treat you fairly, being a foreigner in their courts, and they'll focus on the merits of the case. So to go through just each of the different forms of IP with respect to patents, if you are going to seek patent protection in Brazil, it's important to understand the process. So there are specific formatting requirements. For example, your claims have to be in Jepson claim format, right, where you recite what's already known, characterized by, and then recite what's new. Brazilian attorneys will redraft your claims into that format if you need them to, but as we kind of discussed yesterday, it's much better if you can include in your specification some language that's basically the Jepson claim language, so that that can just be pulled out and put into the claims when you file in Brazil. The format in Brazil is that you file your application and then you have 3 years to file a request for examination. And while you're, you don't go into the line for examination until you file that request for examination. And there's pros and cons to that. On the one hand, you can only amend your claims in a broadening way before you file the request for examination. So once you've done that, then you can only narrow the claims. And of course, the incentive there is to wait to file the request for examination so that you have more time to amend your claims, maybe based on a result in another country. On the other hand, of course, waiting to get your patent examined, your application examined, means that you are also waiting to get an issued patent, and that can contribute to the length of time that it takes to get something issued. You can, speaking of claims, you can include different categories of claims in a single application, which is good because Brazil is very restrictive when it comes to continuations and divisionals. There are no continuations in Brazil. You can file a divisional up until a decision to grant or deny the application has been filed by the Patent Office, and that divisional will be treated as if it's in the same phase as the original application. So the idea really isn't to have sequential examination of applications. The Brazilian Patent Office really wants to examine things all at once. Of course, they can always, like if you were to appeal at the appellate level, if the appellate panel said, we think you need to file a divisional application here, then you'd be allowed to do that even after the final decision at the first instance level, but that's only if the office lets you do that. And then pendency, this is an area that there's lots of misinformation out there, right? Brazil used to have incredibly long pendency, more than 10 years to get a patent issued, and I think because of that, many people just said, look, I'm not going to deal with getting protection in Brazil. That's no longer the case, though. They've tried very hard to bring down the pendency, and now average pendency is closer to 4 years, 4 to 5 years, and whether, how long it will take for your specific application depends on the area that it's in. So, for example, once an application is in queue for examination, in the chemistry, metallurgy, agricultural, packaging areas, you're likely to get a decision in 2 to 3 years. 4 to 5 years for electrical and mechanical inventions, and then if you're in the telecommunications or the biotech areas, then we're talking 4 to 5 years from the request for examination. So those are the areas that take the longest, but these numbers are coming down.
What's the lifetime of the patent?
20 years from filing. Yeah, yeah. And Brazil does belong to all of the relevant treaties, right? TRIPS, PCT, the Paris Convention. Brazil was actually one of the first signatories of the Paris Convention, interestingly. So, yeah, please.
So, if it takes that long, can you still get damages back to the earlier filing if you say, yeah, somebody's already infringing it, but it takes you 4 more years to get the issue back? Can you go back and get damages?
That's a great question. And the way they've incentivized the system is actually, in that case, is actually with respect to accelerated examination options. So if you think someone's infringing, then you can file a request for accelerated examination, which is very fast, less than a year, and then you can get that application issued much more quickly. There are actually a number of accelerated examination options. One of them is the PCT, or I'm sorry, the Patent Prosecution Highway. And under the Patent Prosecution Highway, currently the rules are that each applicant can only file 1 application per week, and then the total number of applications that they'll accept in the PPH program per year is 800 applications. And so typically that's been met in the last couple of years in like the mid-year time frame around July. They just joined global PPH, however, and so we're expecting new rules to come out sometime in the next month or two, defining what the new limits are, if there are going to be new limits, and things like that. There's also accelerated examination programs for green technology, for inventors who are older than 60, for inventors who are sick, right? Some of the same programs that we have here. There's 17 total programs for accelerated examination. And it's very important to talk to the Brazilian attorney about using one of these programs because it can save you so much time and most people don't know about them.
So the divisional needs to be filed before the parent is allowed or before the parent is rejected? Both.
Allowed or finally rejected.
Or finally rejected. So now if the divisional is filed and subsequent to filing the divisional, the parent is rejected, the divisional does not go out of the window. The divisional can continue being prosecuted.
That's right. And that's because the claims will be different, right? And they enforce that there can be no scope overlap between the divisional and the original.
Thank you.
Yeah. Costs $2,000 to $3,000 probably to get an application on file, and then over the course of the examination, you might end up spending another $8,000 to $10,000 or something like that to get it issued. That includes translation costs and things like that. So I'll be more brief with respect to the other forms of IP. On the industrial design, please go ahead.
I heard the same thing before about the long pendency.
Yeah.
But also the grant rate was very low. Is the grant rate going up also?
That's a good question. They don't publish the grant rate data like they do the dependency data, and so I don't have good numbers for you. But my sense is that it's not like you have no chance of getting something issued here. There's a good chance that it won't be as broad as you might see in the U.S., for example. I think examination is harder to get through in Brazil, but it's not like they're rejecting everything, to the extent that helps.
Do they have the equivalent of a CIP?
No. No.
So you've got to file a new application. You have an improvement over
Yep.
the existing one.
Yep.
You don't do a CIP, you just do a brand new application.
What they have actually is called a certificate of addition, and that's just a way to add like a small component to an existing, you can actually do that after the patent's issued.
And priority date, does that change?
No, I don't think priority date changes, but I think it just is an additional right added to the existing patent, so the expiration date will be the same, and it's very, it's not used very much.
You basically don't have the option of a CIP in Brazil.
No. So with industrial designs, there's just been a few interesting developments. One is that they released new examination guidelines within the last year that allow for partial design protection. So you can now show background, which is very common, or I'm sorry, show environment, which is very common here in the US with dashed lines or things like that. You can also now protect animated GUIs, just like you can here in the US. And Brazil joined the Hague Agreement recently, which is of course a great way to enter the country for your design protection. They have had some IT issues with the Hague Agreement. I don't see those as having any long-term impact. It's just something that they have to work through. And then I had mentioned earlier that when a right is challenged, the validity of a right is challenged in Brazil, that case gets filed in federal court and the Patent and Trademark Office is a party to the case. So in Brazil, industrial designs are just registered, so you don't have to have examination, but you can request it. And an issue that's come up is that you register your industrial design in Brazil, then you sue someone on the basis of that right, and the validity of the industrial design is challenged. And now INPI, which has not examined the right, is a defendant in the case, and now they will opine as to whether or not the right is valid, and that might not go your way, right? So there can be benefits to asking them to examine the right when, or examine the design when you file, so that you don't get surprised when they decide that it's invalid when the right gets challenged in court. I'll also say with industrial designs that in the US, we have a much more permissive policy with respect to what can be registered, or I'm sorry, what can be patented with a design patent. In Brazil, it's not that way, right? In Brazil, it really needs to be something that's almost artistic in order to survive the courts, as opposed to something that someone could argue is functional. So for example, I used to represent a company that made attachments for metal roofs. And a lot of their attachments were kind of in block shape. They had different features on them that, that could have been oriented in many ways, could have been designed in many ways, and it was fairly easy to get design patent protection for these attachments in the US, but that wouldn't work in Brazil. They would look at that and say, you know, that's a block and it's accomplishing a very functional purpose. It doesn't matter that there are lots of different ways you could have designed it. We're not going to grant that protection. And then finally on trademarks, so the key thing to know about trademarks in Brazil is that you can only protect what's visually perceptible, so no sounds, no scents, no tactile surfaces, and as far as use requirements, you can register without use, and it's a first-to-file system, but you have 5 years to start using, and if on day 5 years plus 1 someone challenges the mark as not being used, then you will lose the registration if you haven't started using it by that time. And then the trademark department is actually very active right now in looking at potential adjustments to the trademark system. So one of those is that they're considering and plan to implement within the next year the evaluation of acquired distinctiveness during examination. They're also going to make it so that you can protect slogans, which are not currently protectable in Brazil. That's expected to happen this year. And then finally, they're planning to update the regulations regarding what qualifies as a famous mark in Brazil so that that's a more clear issue. Anyway, that's a brief overview of IP in Brazil. I will close by saying that that things move more quickly in Brazil than they do here in terms of IP policy. And generally speaking, the Patent and Trademark Office is fairly approachable. They're willing to hear perspectives, but you have to get engaged if you want to have your voice heard in that process. And so if you are interested or your clients are interested in seeking protection in Brazil, then it's worth being involved on the policy level with what's happening, because you might be able to influence policy in a way that is helpful to your client, and you know, you might even be able to help avoid the implementation of some policy that would be harmful to your client. So with that, I'll stand off the soapbox here and turn it back over.
Just a question.
Yeah, please.
Back to the litigation point. What's the appeal process look like in Brazil?
So very similar to here. There's the trial courts, and then there's appellate courts, and then there's the Supreme Court. So appeals are much cheaper than trials, as is the case here. The Supreme Court has discretion about the cases that it takes. At least the Constitutional Supreme Court has discretion. The non-constitutional Supreme Court, actually, I'm not sure that it does have discretion. It might take every case. But as I said, even that court, the non-constitutional Supreme Court, has panels that are specialized in IP, and so you can get good judges all the way through the process. Any other questions? Thanks.
Thank you, David. So opening it back up to our panel, I think David touched upon, you know, Brazil as a relatively new jurisdiction in which companies may want to file in and engage in more IP activities. A lot of things have changed over the last few years, so I'm just wondering, how has, strategy for foreign filing changed, from your experiences over the past few years, with maybe certain jurisdictions becoming more favorable, others becoming less?
I can't talk about what is becoming less favorable, but my clients are filing more in China,
Okay.
now that, first of all, it's their, destination country where they would like to do business. But I have seen that, now I think the foreign associates in China that we work with, they have actually done a good job in convincing us, the liaison in US, that the Chinese courts are way more multinational, defendant friendly or applicant friendly. So just because it's a multinational based outside of China, your chances of getting an IP is not necessarily low. And even if there is a proven infringement, case, just because the IP holder is based outside of China, the courts will not necessarily forgive the infringer. There will be high damages against a native Chinese company if infringement is proven. So once those kind of cases have been established and multinationals have got good return for filing IP in China, they have been more convinced to keep building a portfolio. So some of my clients said that, we don't want to file a divisional in US, but we want to build the portfolio in China. So that was a very unique case that, I can see the shift in, multinational companies' focus in building a IP portfolio in China.
What about filing in Europe and taking advantage of the Unified Patent Court there? Has any of you experienced what that is like, going through the process and then entering into litigation within the UPC?
I have not seen any activity at the UPC among my clients. I have clients that have, in the last 10 or 15 years, done a lot of litigation in Germany, which was viewed as a very favorable forum for patent enforcement in Europe. I think when the UPC was proposed, it's certainly a very good idea, and it's something that Europe should have. But it's kind of like when a U.S. district court wants to attract patent cases, nobody's going to file there until they know they're going to get a good result, right? So it's sort of a chicken and egg problem. As long as you can still get good results in Germany, it's hard to kind of take a gamble on the new UPC without a larger track record to draw on. I know we have some European and UK lawyers in the audience. Maybe they may have more specific experience, but what I'm seeing is people are still certainly very interested in filing in Europe and getting that protection. But I just personally have not seen any of my clients go to the UPC for enforcement.
Anybody speak to India as just a rise in an IP powerhouse as well?
So yeah, in India, lots of filing is going on, and foreign filing also going on from India to, you can say, US, Europe, and China. And in terms of startups, now they are becoming more aware, and the government also incentivize the startup owners and founders, because they just need to file, give the government fees, and the rest of the reimbursement will be done by government to the IP attorneys with the scheme, with the startup scheme. So such type of initiatives has been done, and the industry is booming, and same is the IP industry also booming in India. So yeah.
No, that makes sense.
Something interesting about the developing countries that I've been observing is, patent filings in India, in a lot of other developing countries have increased substantially over the last 10 years, probably by 100 or 200%. I don't remember the numbers exactly right now. But 70-80% of those filings that have increased in these patent offices are actually national phase filings. So still, there isn't that kind of homegrown invention activity taking place in countries like India. I don't know so much about China, but I know that China has been filing very aggressively in the US. But in a country like India, the massive boom in patent filings has happened as a result of tons of national phase applications coming in.
So I can say, for China is also aggressively filing in their own country, and the best part is the enforcement is become very effective nowadays. So they can stop and it's very fast. So that's a very great news.
I think in the past, maybe 6 to 8 years ago, the Chinese courts did not appear to be as favorable to foreign filers as they were to domestic companies, and it sounds like that sentiment has changed a bit based on your experiences. What else do you asked your clients to think about it as you think about a foreign filing strategy? There is a very, very long list of companies countries in which to choose from. Most of them live on the PCT, 2 of them probably don't. How do you get your clients thinking about where they should be filing, and what are the discussions that you walk them through to make a decision?
The first point is what's their business in which country they are doing the business, and from which country they are either hiring people or sourcing the products. So these 2 countries are most important, first of all, and then they need to see like the expansion. That expansion strategy will come along later, but the best policy and strategy is that to delay the prosecution. Right, file a provisional, then file a PCT, then you have ample of time to delay the prosecution. And then in that meantime, you can grow your company, have funds, and then you can go to the national ways of any country.
Makes sense.
Mostly it's cost, you know.
Yeah.
PCT is very attractive because you just pay one, filing fee, and then you can convince very easily to all the CEOs that your rights are secured for in 169 countries. So everybody agrees to file a PCT. Then suddenly when you say that, okay, now in Europe itself you need to, spend this much money to validate your patents, even after getting the European patent granted. The validation cost and all of that. Some people say, oh, I didn't realize translation cost this much. So basically you have to be very upfront with the upcoming costs of. I basically encourage my clients to really think through whether it makes sense for them to seek patent protection in, and then it usually comes down to just, okay, file it in these 3 countries, and sometimes I don't even have to file a EP patent if they know that they're only going to do business in Germany, then they'll do a direct foreign filing there. So those kind of considerations. So usually, the startup founders are pretty savvy in terms of understanding these things. If you have a conversation that is, free of legal jargon, but just bring the dollar value. So we have a cost estimator available in our firm. So our foreign filing specialist can actually, given a size of the patent application, how many pages, and they would give a cost estimate for. And then, that always helps. We provide an estimate. Then we always, give them the disclaimer that, this is based on historic data, but if your, subject matter is like business method, maybe in Europe, it'll be like the hurdle to get a patent is higher, so we have to do multiple rounds of prosecution, so the cost might be, but usually given an estimate as a first step, I think that's fair to the client to know that this is going to be the upcoming cost.
I'm going to chime in for a second. This issue is slightly tangential, but if you're going to, I think you need to really decide up front when you're filing the first application, whether you're going to eventually file it or not, because otherwise the result might surprise you. For example, if you filed a 100-page provisional, translation costs when you go to a foreign country are going to be brutal. If you filed a PCT, there's some things that people are not aware of. I think foreign attorneys are aware of this, but if you filed a PCT with 40 claims, when you try to actually go to international phase in China, you need to cut them down, obviously, but the Chinese Patent Office is going to make you pay for the original PCT claims before they allow you to amend. So you're going to pay those claim fees anyway. The other thing is the way if you are going to do foreign filing, that your U.S. attorney should be aware that you plan to foreign file. I always tell them do that up front, because the application may need to be drafted differently. The draft that works for the USPTO is not necessarily the best possible draft for the EPO, for example. I mean, the EPO is probably the most worry about the most, because that format works for almost everyone else. You need to draft it, keeping the European amendment practice in mind, the fact that you can make a basis for amendments later on. So you need to just plan for it right up front.
Just a regular, like real life story, like incorporation by reference, which is in US. Sometimes I have just mentioned that, this previous patent is incorporated by reference in its entirety here. And that was enough for the US prosecution. They said, okay, you have to show this feature, and I didn't have that shown claimed feature in the original drawings for a particular patent, but I have mentioned an earlier patent. So I could even add a drawing to my patent, because incorporation by reference is, very lenient in US. But there was no chance of getting that additional. It doesn't work in anywhere else. So it's a very important point, Subrata, that when you know that you're going to foreign file, that you have to draft the original patent differently.
Thank you. Matthew, I wanted to ask you a question which was came up when you were making an introduction about IP strategy. You mentioned that one of the first questions you ask is kind of what company you want to be. Is it a practicing company? Is it a licensing company? And sort of what's the role of IP within that construct? What are the big changes in terms of recommendation, in terms of strategy that you give to your clients based on what they want to be as a company?
Sure. So, I mean, there's obviously all different kinds of companies. There are some startups that are based on one core idea that can be claimed in different ways, and so there's a lot of focus on developing that idea, protecting that idea, and that's when we talk about how to effectively protect it without spending a lot of money at the outset. Kind of on the other spectrum are sort of large technology companies that are just sort of have the steady grind of research and development. They have engineers that are coming up with new ideas every day, and they need a way to figure out how to identify and protect things that they want to protect. So one thing I've done for companies in that situation is patent incentive programs. I don't know if anybody here has worked with those. The basic idea is that you encourage your employees to submit an invention disclosure statement, and then you can reward them in various ways. So if a patent is filed, they get a bonus on their paycheck. If the patent is allowed, they get a bonus on their paycheck. The one thing you absolutely have to do if you're going to do that is get your employment counsel involved, because if you're altering employment contracts on the fly like that, that can create issues. It is critical to do that if you're trying to do that in multiple countries, because different countries have different laws about how inventors are compensated and what rights they retain in their patents. So in the US, it's very easy. Right? Nothing's very easy, but it's relatively simple because an employee can just assign all of their intellectual property to their employer and then they own it. But even that, I had to research this issue recently for a case. There's all kinds of case law out there on the difference between an employment contract that says, I hereby assign everything I invent in the course of my employment, or I hereby agree to assign everything I invent in the course of my employment. Those are two different promises, and they're enforced differently. And then down the road, that affects the standing to assert the patent and the ownership. Another thing we haven't touched on, it came up yesterday, is trade secrets, right? There's the choice of, do I want to protect this as a trade secret or a patent? I forgot your name, but you mentioned yesterday that you don't like trade secrets. I agree with you. I mean, trade secrets are valuable. Every company should have.
Actually, let me just rephrase what I said, because it was more in the context of a lot of work that I do is in the software.
Yeah.
And you don't need to patent your source code. You're basically patenting your systems and methods. Now, in the context of that, those systems and methods, they can be implemented multiple different ways. So to not have a patent on the system and method and keep that system and method as a trade secret for me is a bit.
Yeah, and I didn't mean to make such a broad claim. I mean, obviously, if you have something that is best kept as a trade secret, you should absolutely put your reasonable measures in place to protect it. You should have that written down. Like, this is how we protect our secrets at this company. That way, if you have to enforce your trade secrets somewhere down the road, you have something you can submit in discovery. Like, one of the elements of a trade secret misappropriation claim is that your secrets are subject to reasonable protection, and then you can just put that in evidence and you've checked that box. On the other hand, trade secrets are very difficult to enforce in court. You have to, and I think we all know this, I won't go through the black letter law, but and again, kind of bringing the employment counsel in, I've done a lot of trade secret cases. A lot of trade secret cases are actually employment disputes. An employee leaves a company, starts working for a competitor. The former employer, takes it personally, gets angry, says, well, they must have taken some of our knowledge and know-how and secrets, and now they're using it to compete against us, and I'm really angry about that, so I'm going to sue them. Maybe that's true, maybe it's not. I mean, it happens, it doesn't happen. But proving that is extremely difficult, and those cases get extremely contentious and extremely emotional. How much easier would it be if you had a patent? You just say, look, they're practicing the patent, they have to stop doing that. I'm obviously oversimplifying, but those are the kind of considerations that I've talked to with my clients. And then also, I don't want to monopolize the time too much, but since we are talking about IP generally, trademark is very important, especially in the software space. You have a name, you have a brand, you have people who associate you with high quality. You have nefarious people out there trading on your name, especially if you're an open source. I mean, you have to be really aggressive about establishing your name, establishing the recognition, and enforcing that. So my clients do a lot of monitoring of URLs, monitoring of trademark filings to see if anybody's stepping on their toes. And the way the U.S. legal system is set up with trademarks is it's very much a use it or lose it. If you're not aggressive about protecting your trademark, you risk losing it. Quick story. Some of you may have heard about the Starbucks Charbucks case in the Second Circuit a few years ago. Anybody? Okay. So Starbucks, the coffee company, there was a literal mom and pop coffee shop in New Hampshire selling Charbucks coffee. And it turns out that Charbucks is a derisive term in the East Coast coffee culture for the kind of really dark, over-roasted West Coast style of beans that they don't like. But they were selling a dark roast and calling it Charbucks. Literal, I'm serious. It was a mom and pop running a coffee shop. Starbucks sued them for trademark infringement. It went to the Second Circuit 3 times after a bench trial and 2 remands. And they ultimately lost. I handled the third appeal. I can tell you the full story over a beer sometime. But those and it was covered in the press like, oh, Starbucks is being unreasonable. Like, why can't they just leave these people alone and this and that and this and that. As IP lawyers, we know, you don't have that option. If you let one infringer go, you really risk weakening and ultimately losing your mark. So, setting aside the resources to URL monitor, filing monitor, just kind of do all these measures to make sure that nobody's stealing your trademark is also important.
Just really quickly, I'll reinforce something that Matt said, which is that we need to make sure that clients understand that just because they're going to use trade secrets instead of patents to protect their IP doesn't mean that they don't have to spend any money or do anything extra, right? They need a written trade secret policy. It needs to be robust. They have to take reasonable measures, at least reasonable measures, to keep that secret active. So something to keep in mind.
And as outside counsel, we can help with that. We know the case law. We can say, this jurisdiction, you have to do this. Under the federal jurisdiction, do this, 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 and this. This will check that box when you ultimately sue somebody for stealing a trade secret.
Mitai, I know we had also talked a little bit about, the idea of trade secrets versus patenting for some of your clients and your recommendation. I guess, what are some best practices that you'd want to share with the group here around that topic of when the...
Yeah, so, of course, I'm a patent attorney, so, and I would always tell them to file a patent, but one thing I mentioned yesterday, so it might be a repeat for some people, that sometimes I say that filing a provisional can be an intermediate way of preserving something as a trade secret for about a year. And at that point, you can decide whether to file, patent application or just not pursue that. So you just decide that, I'll keep that. But if you decide to file a patent application and you're only filing in US, then you can still file a non-publication request. So the kind of the pseudo trade secret path continues throughout the prosecution until you get a patent. So once you get a patent, then it gets published and everybody gets to know about what's the content of the patent. But I have used that actually strategy that, we decided with the client that, this is not going to be filed elsewhere. So we basically filed a provisional, then filed a non-provisional with a non-publication request, and went through 3-4 rounds of prosecution. We were not overcoming the abstract idea rejection at all. We, overcame all the prior art, but at some point, the inventor said, "No, I don't want to pursue this patent application anymore, but I still own the technology." So it kind of remained as a trade secret with him. So I thought, so after experiencing that, I now use it as a strategy to kind of reach a middle ground between trade secret and patent application. So.
Well, and that raises a good point, because with a trade secret, you don't have all these 101 issues. I mean, if it affords you a competitive advantage and you're keeping it secret is beneficial to your business and you're taking reasonable measures, that's a trade secret. I mean, a customer list could be a trade secret. There's tons of cases that are just a list of names. So if you have some sort of innovation or technology that's helping your business and you don't feel like you can get it past 101, treat it as a trade secret.
Yeah, I think the whole trade secret thing assumes a little bit of significance if your claims are structured in such a way that they will not be able to read upon easily detectable forms of infringement. That's number one. But in the world of technology that we live in, there are so many different ways of accomplishing the same thing. Thomas Edison got his patents for the diesel generator and kept it as a trade secret, a method of generating electricity. It's highly unlikely that the world wouldn't have figured out how to generate electricity. So it really depends on the realm and the space you are in. But in a space like tech and high tech, which is semiconductor, software, AI, etc., it's moving as rapidly as it is. There are lots of people doing the same thing, isolated from each other at the same time and coming to the same conclusion. So I'm a big fan of the patent system in that sense.
I'm just thinking about the Starbucks issue, and I think I saw it. It's not too long ago, about maybe 2 or 3 PS or so. But it's just
I would say about 7 or 8 years ago, but yeah.
Oh, okay, sure. What would be the best way to prepare client for that? As you engage in this protection process, particularly for a trademark. To say let's assist you to manage your expectation insofar as this protection is concerned. Something like this might happen. I mean, there would be a case of maybe unlawful competition and not necessarily a person who has registered a mark that we are trying to register for you. How best can we, because I'm just trying to think, how best can we prepare client for such situations, to say something like this might happen, and if it happens, this is how we may approach it. We might get judgment in our favor. If we don't, know that we may not get it because of these reasons.
Yes. I mean, I think that kind of gets to a broader challenge, which is getting clients to understand what IP is, how it works, and why it's valuable. So, going back to patents for a minute, I mean, I'll often have referrals call me and say, hey, I have this idea, and so, this friend of yours told me I should get a patent. And I always ask, well, okay, that's great, please do that, but why do you want a patent? Like, do you know what a patent is? Do you know how you're gonna use it? With trademarks, I think, it's easier for companies to get this idea, well, this is the name of my company, I'll register it, and nobody's allowed to use it, and I don't have to worry about it. There are services that will, just Google search your trademark every morning to see if anybody's using it. You can monitor trademark office filings. But I do think you need to prepare, just like investing resources in trade secret protection, you need to invest resources in trademark enforcement. And a lot of times, if somebody is infringing your trademark, if you send them a threatening letter, either from your own legal department or from your outside counsel, as long as it has a scary letterhead on it, and the target is small enough, they'll just stop. There was this famous practice years ago before Disney acquired it, where Lucasfilm was extremely aggressive about Star Wars trademarks, and there were all these bloggers and people had fan sites and everything that were using Star Wars trademarks, and Lucasfilm would send them a letter on Lucasfilm letterhead saying, cease and desist, blah, 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 blah. And most of the people doing that were so tickled that they got a letter from Lucasfilm that they would post that on their website. That, hey, look, I just got this letter from Lucasfilm. And then they would stop doing whatever they were doing that was making them mad because there was goodwill there. But on the other hand, you could go to the Second Circuit 3 times, right? So I think it's just managing, just like with any legal issue, you just have to manage cost expectations and say, this could cost you a lot of money, so be prepared for it.
Yeah, I think on the topic of just bringing the client along on this IP journey, we are all IP professionals. We understand IP pretty well and clear, but most people don't outside of a profession. And so I just kind of like to ask the panel again, what are some of the best practices that you have encountered that will really help to bring your client along in terms of understanding IP strategy, understanding IP best practices, how to get them to focus on a topic where one would argue that traditionally people think of it as a legal topic and one that board members and management is less interested in discussing.
Okay, the best point is if the client is aware of the IP, a little bit IP laws, and they are aware of what's the benefit of filing patents and everything. So it's easy to get along with him. So it's easy to make him understand the process, and it's easy to because board members never get involved in these things. So there is a CTO or R&D manager or R&D team will be involved in the same. So if the team is also well educated about the process and everything, so it make very easy life for an IP attorney. Right. So yeah.
So one of the things especially in the patent area, one of the things people that need education about is what is really patentable, because typically most engineers set the threshold very high, and it's the actual, when you can get patents for, they don't think it's something is being patentable unless it's a really complex idea. And that's not true. Some of the best patents are actually on very simple ideas. So one of the things I started doing at several companies is, I used to be a patent litigator for many years. Almost all my cases I was defending against NPEs. So I've seen some very simple, I would say, annoying claims that were eventually were worth a lot of money in terms of judgments. So I started showing them, I showed people some typical NPE claims and asked them, do you think this is patentable? Have them go through the whole thing, and then I tell them what happened in some of those litigations, who got sued. That helps. The other thing is to actually just have an open communication. I don't necessarily, we have an invention disclosure process, an invention disclosure come in, but I routinely just talk to people about what they're working on. And I do harvesting right at the inception of the invention. And we start working in invention disclosure at the very beginning, before, and sort of long, sometimes I do most of my strategy at the invention disclosure level rather than how does the patent get drafted. I'll work with the inventor on what the idea is, what more would I need to actually have a strong patent. Sometimes a little bit of the work is done because I'm asking for it. I make them develop the idea further than what they're going to implement today. I make them think what they would want 5 years down the road, because that's when the patent is going to come out. And if you do it, and I do this all without any legalese. My rule is I don't use novelty, I don't use obviousness in any conversations. And if people some serial inventors, if they start using them, I'll stop them basically and say, no, let's not worry about the patent. Let's talk about your idea. And that is, I found it extremely helpful. And if you keep the conversation interesting, then people actually, people buy in. I mean, some of the most sort of prolific inventors that at some point I've been involved in discussions before they actually start discussing the idea internally inside the company. We'll discuss it together. And that's always flattering that they do that. So that communication, same thing with marketing. You need to, if you're in-house, it's hard for law firms to do this, but if you're in-house, it's vital to actually talk to marketing, to see what their roadmap is, what's going to be important for them 5 years down the road, where do they see their markets 5 or 10 years down the road. That's important both for deciding for what countries to file a patent in, as well as for trademarks, because the kind of because trademarks, just like domain name squatting, trademark squatting also exists. And if you think you're going to be in some countries down the road that are risky, you should just file them. And Brazil is an important one, actually. It turns out, I think you know this, that filing a trademark in Brazil is one of the cheapest countries to file a trademark in, and it's one of the cheapest countries to get a trademark renewed. So even if you don't have an interest in Brazil today, but you think you might have something interest like 10 years down the road, it's good, but it's subject to cancellation. If no one contests this, you're fine. You can't keep the trademark. But if you don't file and you need something in 5 years, you're out of luck, because they get to keep it for 5 years and they're not going to sell it to you. So, and there are a lot of other countries like that. So.
Sorry. One of the I agree with everything that you guys have said. A couple of interesting things about involving marketing people in the patent process is suddenly you'll get a write-up which is full of, we're going to save this much money, this, that, without any technical details. So it's like the utility of the patent from a business point of view minus any technical details. So a lot of the times I had to convince people that I don't need to know how much money this is going to save. I need to know the technical details of how you're implementing it. So that how part is the most important thing in a patent application. So a lot of the times, during harvesting and everything, everybody is super excited that we're going to get a patent, but I don't have enough to write anything. It's a very high level concept. So that drilling down that process of getting details out of the inventors after the harvesting, that is a challenge. And the more I'm an outside counsel, of course, the more the in-house people, have regular discussion with their inventors that, when you're filling out the invention disclosure form, include details. And the more details there are already we are expensive attorneys. We don't need to charge you for an extra hour asking for details if the details are already there. So I think, one of the ways to kind of integrate us outside counsels in the patent, effective patent strategy for a company is to basically educate the in-house people of how they can, without paying the hourly fees of the outside attorneys, educate their inventors. Even create some drawings, don't use too many colors, because most of the patent drawings are going to be in black and white. So, if you are creating something where color is an essential part to convey the idea, can you do that in a different way so that the attorney doesn't have to spend extra money converting the color drawing? Those kind of very practical, simple things, I think, just synergy between the in-house counsel and outside counsel can make the patent process very interesting. I'm talking about patent again, there are other experts for the other IP.
So I think a big challenge here, I think you've alluded to it, is that in a lot of companies, the legal is a cost center as opposed to a revenue generator. And that can be hard for companies to tolerate. Even you can rationalize it and say well, it's like paying $100 a month for a home security service. Ideally, you'll never use it, but you're not going to stop paying for it, because then you're opening yourself up to harm. So there are a couple of ways. There are a couple of ways to educate clients on that. I think, depending on the various levels of sophistication. I mean, I think, as I said at the outset, just tying the IP into the business objectives of the company, I think, is critical. There are ways that IP can promote the business, not just protect the business, particularly on the trademark side. On the patent side, I think one of the most important services that lawyers provide to their clients is risk management and risk mitigation. So you don't want to go to your board or your CLO and with a bunch of gloom and doom, like if you don't do this, your company is going to collapse. But this is another opportunity to bring in the marketing people or the PR people and say, well, what is happening out there in the industry that we're in? How many competitors do we have that are getting really close to our product, are doing certain things slightly better than we are, might want to rip off our idea and do it themselves? How many of our competitors are getting sued for patent infringement? In the semiconductor space and in the telecom space, it's really high. In other industries, it's lower. And I think just keeping the client apprised of the risks of kind of short shrifting the legal strategy, I think, is a good way to bring them along. Along with, again, just the positive benefits like branding, name recognition, being able to leverage your patents against your competitors if you have to, being protected against former employees leaving and taking your secrets to somebody else. Just, don't, I think it's easier for lawyers to just say, okay, well, ask me a legal question, I'll give you the answer, and just trust me. That doesn't work when you're asking the client to spend a lot of money on a comprehensive strategy that's going to protect and promote the business. And I think you just need to trust your clients to be sophisticated, be intelligent, and understand IP just as well as you do, and help them get there with you, and that will help them be a good partner in the strategy.
I agree with everything that's been said. I mean, the reality is that as IP attorneys, we tend to enjoy talking about what we do, right? And I think one of the most enjoyable parts of this job is educating clients about IP. And I think that's critical so that they can make the best informed decisions about how to proceed with IP. It certainly helps if we can learn to speak some of the business language, and if we can sell IP in a more effective way, not in terms of you need this because it's important to have a patent, but you need this because this is how it's going to help you achieve your business objectives. That matters to business people, and that's what's going to ultimately make them want to invest in IP protections. So I don't know that I have any other techniques to suggest, but I would just reiterate how important it is to be educating our clients, and that the more we can educate them, they educate others. That makes all of our lives a little bit easier.
Yeah, sure. I also agree with the the education part of it. Holding their hand, and you mentioned something about competition and analysis. That also works to our advantages as advisors. For instance, you would be looking at what your clients' competitors are doing and how they also addressing their IP issues. So it becomes somewhat easier to then sell your strategy to them, looking at what competitors are doing. For instance, there's a number of classes that Uber and Bolt have protected their trademarks under for what they do as businesses. Just running a search on them. Your client is a startup that wants to get into that market. It becomes very easy for you to sell it to them to say you need to have a look at class 3, class 4, and these are the classes because that's what your competitors are already have already protected under, and that helps a lot. And avoid cutting also corners, which is something came up yesterday about. Do you run a search? Do you conduct a search or not? I mean, with trademarks, I wouldn't want to move without having conducted a search, because with that at least I get a view of what the road is likely to look like. I know it wouldn't be comprehensive. Starbucks, I'm sure they conducted a search, but still had to deal with this issue of the mom and dad coffee shop that became a problem to them. But with that search, at least you are able to also prepare a very comprehensive legal opinion that says to your client, ahead of filing, these are the red flags, these are my concerns. But I'm here. Let's forge ahead, and if anything happens, this is how we will deal with it. So that's about it for me.
Thank you. I know we've been running for a while, so maybe at this point I'll turn it over to the audience, see if there's any questions. Yes.
It's not really a question, just a comment.
Thank you very much. So it's just a couple of quick words on the UPC that the panel raised earlier. What we're seeing is that a lot of our larger clients especially are instructing us to opt their cases out of the UPC's jurisdiction, which is going to continue to be possible for another few years. That option will still be available. There are, as I understand it, of the order of 200 or 300 pending UPC cases. But the main forum for challenging validity of European patents remains the European Patent Office, because procedurally it's a lot simpler and the costs are a lot lower.
Are you still seeing on the enforcement side, it's still primarily going through Germany?
From my limited experience on the enforcement side, Germany is still quite popular. I think
the German gentleman is nodding behind you. So.
Are there, maybe we should have you come sit on the panel, are there specific types of companies that are focused on using UPC or that are more willing to use it than others?
Interestingly, the small number of clients who I've worked with who have opted for unitary patent protection have been the smaller clients, where they can benefit from covering a larger number of countries just by filing one translation of the application. The larger clients seem to be more risk averse with as you mentioned, the UPC is a very new system, so there's a lot of uncertainty.
I'll just ask, in general, thoughts on omnibus specifications. They're going to spawn a lot of divisional situations or sort of narrowly tailored specifications. One patent, sort of one and done. Any general thoughts on that? And maybe with regard to filing internationally, what you like or don't like, or what your experiences have been?
So I'll chime in. So omnibus patents are a good idea only if you don't plan to foreign file, because as I said, it gets very expensive. It's not you're going to regret it if you do that. Other thing to watch out for is if you're I don't know if you're in-house or at a law firm, but if a law firm is drafting an omnibus patent for you, make sure actually they are really drafting something that matters. Because I've seen omnibus patents at startups where there's a very long patent application, but a lot of it was just textbook. It was not relevant to the invention. It's just a lot of background information, a lot of stuff that's in the prior art. So, but otherwise, if you have a complex invention, very complicated system, you're not really sure how you're going to claim it someday, then omnibus patents make sense. And the one sort of way to think about it is, if you think of a patent as a property right, omnibus patent essentially lets you claim a very large piece of land, and then you could build your house wherever you want to later on. And so it's useful in that sense. But I would do it only for the US only applications.
Thank you so much, Kelvin. So now it's time to honor our panelists and for this session. So we can have a group photo for this session. Please come on the stage. All right, thank you so much. So before we move to our networking lunch break, I request you all to come on the stage and have a group photo for the for IIPLA 2024. Thank you. Yeah, everyone. Yes, now. Thank you. So we can all stand over here.
So in different groups? No, all the short people medium sized.
So we can have few of the people standing in upstairs.
So there's one person.
I think I should do
No, I mean, it seems like if you really want to generalize it, my arm is very strong, but I don't know
Why not? You guys can get closer.